But they should be here any minute by
Yeah. Morning, folks.
Good morning.
Mrs. Brain told me yesterday, if you don't mind me talking, Judge, called me yesterday and said this case, Sophia Coleman, which is set for exam in front of Judge Giles, is in the wrong courtroom, and I believe she's accurate. It's supposed to be before you because it's a DV case. So we are both appearing today in order to pick an exam date and have the case moved to your courtroom if you agree with that.
Okay, no problem.
Meanwhile, I'm in Oakland County. I'm just waiting. You know, everybody's late today. It's a very slow road day.
Mr. Johnson, good morning. You're here on Sierra Jones, correct?
Yes, Judge. Good morning.
Good morning. Mr. Kehoe, are you here on Jones?
Yes, Judge.
Okay, we're ready on Sierra Jones.
Call the case number 230568310 People State Michigan versus Sierra Jones. Defendant is charged in count 1 homicide murder for the premeditated.
Appearances for the record, please.
Good morning, Your Honor. My name is James Kehoe. My P number is 82812 on behalf of the people.
Good morning. May it please the court. Bertram Johnson appearing on behalf of Sierra Marie Jones, P46646.
Are you waiving Ms. Jones' presence?
Yes, Judge. Your clerk informed me that she had an episode and they couldn't produce her this morning. I visited her last night and she was fine. So yes, I waive her presence.
Do we have a report back from the forensic center?
No, Judge.
No.
I sent an email to the Forensic Center yesterday. They sent me one back. She is supposed to be being evaluated today, but in light of what Ms. Reynolds had told us, I don't know if that's actually going to happen or not, but they were not ready today, Judge.
Okay. That being the case, then they're just going to maybe evaluate her today. They're going to need at least 60 days to get a report back to us. Actually, it'll probably be 90. I mean, set it for 60. See where we stand. I will adjourn the competency hearing to March 18th at 8:30.
That's a good date, Judge.
All right. Thank you very much. Happy New Year to you.
Thank you. Happy New Year to you, Judge, and your staff.
Mr. Davis.
Morning, Your Honor.
Good morning. So you're here on Rollins? No, I'm sorry. You're here on Plum. Robert Plum.
Yes.
Okay. Ready on Plum?
Case number 240550160 for the state Michigan versus Robert Plum. Defendant is charged in count 1 on the basis third degree. Defendant has a habitual criminal record.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Maurice Davis, P76203, appearing with Robert Plunk, who should be present, maybe in the breakout room.
You don't have him. Are you waiving his presence or you want to wait on him?
You have him, okay. Yes, I can waive his presence.
Could wait his presence for your question.
So, Madam Prosecutor, you sent over the discovery.
I just sent you a link for all of the digital discovery that I have. I still don't have all of the paper discovery, but I should have that later today. And then I'll send that over to you.
Can we set another probable cause conference for now, Judge? I want to make sure I have everything before we schedule any exams.
Confident Mr. Drain is going to get you what you need. Is there a possibility this may resolve itself short of the exam?
I'm not sure. Yeah, I don't know. I haven't reviewed any of the reports yet.
I will adjourn the probable cause conference to January 24th at 8:30.
June 24th, 8:30.
We continue.
That works. Judge, I did want to address, my client's on a tether. There's certain time restrictions. He's a business owner. So right now he has a curfew from 9 p.m. to 6 a.m. Wanted to see if the court would extend his curfew. He works as a general contractor. Sometimes he has to be at a particular home, working on that home late. The court would grant him until 12 a.m. so that he can run his business.
What home is he working at 12 a.m.? Who does that?
That's what he does. That's what he let me know. That's just, sometimes he may be out late.
That doesn't sound reasonable or probable. I think the time that he has is a reasonable time.
All right, I'll let him know.
I'll continue. Thank you.
Thanks.
Mr. Nadeau. Scott Nadeau. Mr. Nadeau.
Hi there.
What's your client's name again?
Coleman. Tamia Coleman. Hi, Ms. Drain.
Good morning.
I left a message with you yesterday. Perhaps we could talk after this hearing.
Yes, absolutely.
All right, thank you. I have a case number for you, Judge, if you need it. Do you need a case number?
No.
All right, thank you.
Case number 2306 or 8701 for Michigan versus Tamia Coleman. Discharged in count 1 through 4. Assault with a dangerous weapon. Count 5. Domestic violence.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And Scott Nadeau, P64316, on behalf of Tamia Coleman, who I believe is in the waiting room, but I'll waive her presence for the purpose of this hearing.
Court await the defendant's presence.
Thank you.
What's your pleasure?
Ms. Drain?
I guess just set it for exam.
Yep. I believe we have to transfer the case over to you, but if that's already been done, then yes, let's just set it for an exam.
Court will continue to plead not guilty and set this matter for preliminary examination. How is January 24th at 9:30?
January 24th?
Yes.
Hold on, just give me a moment, Judge. It's in the next week.
That's right.
9:30. I think I'm going to be in trial on that day. I have a trial next week. It might be over, but I don't want to double schedule.
January 26th at 9:15.
Yeah, that should work. That should work.
Ms. Coleman, tell us your name for the record.
Tamia Coleman.
Hey, Ms. Coleman, your next court date is January 26th at 9:15. That's in person in 36th District Court.
Okay.
Final will continue. Thank you.
Thank you. Bye now. All right.
The train from the restaurant. The train from the restaurant. So.
All right. I'm good. How about yourself?
Thank you, Brian. Thank you. All right. Take you back to, you said everything, you know. I think maybe Brian, you get time to.
All right, look. lots. Yeah. 2996.
Anyone here for our 10 o'clock?
Prosecutors here. That's the time. So,
This is Judge Kenneth. Attorney for Mr. Shelby. Secretary Shelby. Yes. 303-965-2288. Yes. Jason, sorry, it's great. I was wrong. Set the January examination. Yes. Just.
Morning.
Mr. Schuler,
Yeah, I'm just walking across the street. I just want to let you know I'm walking across the street. I'm sorry about my delay.
okay,
Yeah, I'll see you in about 1 minute.
okay.
Got witness to this show. Prosecutor's time.
ready, with the copy of the review statement. Thank you so much.
You ready on Rollins? Grapevine Rollins. Calling case 2360376 for the state of Michigan versus Grapevine, Cortez Rollins. Defendant is charged in count 1 homicide, murder, 2nd degree. Count 2, weapons, firearms, possession by felon. Count 3 and 4, felony firearm. Defendant has a habitual offender, second offense notice. Appearances no prejudice.
Dominic Grazia, P69815 on behalf of the people.
And good morning, Your Honor. Stanford Shulman, P43230, appearing on behalf of Grapevine Cortez Rollins, who stands to my left. Those are holding, sir.
Is date time set for preliminary examination? Are we ready to proceed?
Yes, sir. Yes, Your Honor. We want one very.
Go ahead.
The discovery reflects there was potentially a hidden camera that was captured parts of the altercation leading up to the event. Part of the discovery, it was a neighbor who I'll identify as Denise Ledbetter. And the OIC is here today, and I inquired whether that exists as part of grading materials. He's representing that follow up, and that does not exist. There's no green camera. My investigator came up with the same, but I just wanted to make sure before we started that. So days, years, it might come up. We know that doesn't exist. We asked for it. Follow up.
It doesn't exist, we can't produce it.
I agree, Judge. I think that's a fair representation.
Okay. Any other preliminary matters?
Yes, Judge. First, I would ask for an order of mutual sequestration with exception to the officer in charge.
Okay.
Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, ordering you to log off at this time. If there are any witnesses or potential witnesses in the audience, I'm going to ask that you step into the hallway until further notice. Also, ladies and gentlemen, I recognize that I'll wait till you guys come in. Now you're going to have to remove your hat. Thank you. Ladies and gentlemen, I recognize that matters like these can be rather emotional. If for whatever reason you're unable to control yourself, I urge you to step into the hallway. It's better that you leave out the door that you came in rather than leave out the door to stage right. If there are any disturbances whatsoever, they will be dealt with accordingly. Everybody understand? That being said, there are to be no disturbances whatsoever. I should need to know that you guys are here, okay?
The second matter is that I'm moving for the admission of People's Proposed Exhibit 1, which is a postmortem report authored by Dr. Catherine Perez of the Wayne County Medical Examiner's Office concerning an examination of the body of Ron G. Williams on November 6th of 2023.
So stipulated.
All right. Receive that stipulation.
That report indicates that Mr. Williams' death was caused by multiple gunshot wounds, specifically 10 gunshot wounds, including 2 to the head, and that the manner of his death was homicide.
That for example.
Okay.
I believe there's also a stipulation for the preliminary exam only for purposes of a felon in possession charge that at the time of these alleged offenses, the defendant had previously been convicted of a felony and was ineligible to possess a firearm at the time of these alleged offenses.
Again, so stipulated for purposes of the exam.
Or receive that stipulation.
Right. At this time, Your Honor, who would call Rashawn Baker.
Mr. Rollins wants to ask for an adjournment of this exam.
Why?
I don't.
I can't hear you, sir.
No, sir. I got somebody on face as attorney.
Can't hear you, sir. What?
Paid for attorney to retain me on this matter.
Who?
Grant Alexander Job.
Where is he? He hasn't been in contact with this court and asked for an
There's
adjournment.
supposed to be contacting today.
He
I
was
called him
contacted.
early this morning.
He knows me very, very well.
He knows the court very well too. I haven't heard from him. And that request will be denied.
Thank you.
So, ma'am, please step forward, give your name and spelling to the young lady that's seated over here. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat in the witness box next to me. Keep your voice up nice and loud and speak into that microphone that's going to be to your left. In fact, you can pick that up and place it in your lap so that we can hear you. You may begin when you're ready.
Good morning, ma'am. Could you please state your name?
LaShonda Mayberry.
All right. Now, ma'am, I want to ask you about some events that occurred on November 5th of 2023 at around 12 o'clock at night. Remember that date and time at all?
Yes,
All right. And around that time and on that date, were you in the area of 9776 East Outer Drive in the city of Detroit?
yes,
All right. Now, at that time and place, did you know, was a person by the name of Ron Williams there with you?
Just start reading. I always thought, I think it's topic.
Yes.
What was the answer to that question?
yes,
All right. And how at that time did you know a person by the name of Ron Williams?
we were dating.
All right. And how long had you known him prior to November 5th of 2020?
Ron,
Yes.
like a year and a half.
All right. And are you also familiar with a person by the name of Takara Ballard?
Yes,
And what's her relationship to you?
that's my cousin.
All right. Now, at that time, was she also living at 9776 East Outer Drive?
Yes.
Okay.
That's
All right. So is this an apartment or a standalone home? Can you describe it at all?
It's a two-family flat.
All right. And so she lived upstairs. Did you live upstairs with her or in a different place? Apartment?
I live downstairs.
All right. And do you know around that time whether Miss Ballard was dating you?
Yes,
All right. Do you see the person that she was dating and point to that?
yes.
Can you point to that person, describe what they're wearing?
Green shirt.
It's good to kind of.
So no witness has identified the defendant in this matter, Ray Barr, Cortez Roberts.
All right. Now, in the course of you living at that address with your cousin also living in the upstairs flat, had you seen Mr. Rollins before that night at all?
Yes,
How many times or do you think you've seen him?
about a dozen times.
Okay. And you recall at all, like, maybe what month or year was the first time you'd ever seen or met Mr. Rollins?
I've never officially met him. I saw him, like last summer.
Okay. So when we say last summer, are we talking like the summer of 2023?
Summer of 2023.
And around that time, I'm talking now on November 5th of 2023, did you ever have a conversation with your cousin about Mr. Rollins coming into the home?
Yes,
All right. And did you want Mr. Rollins to come inside your home?
no,
Why is that?
they were arguing. It was It was the tenth situation.
Okay. And, did you have this conversation with Ms. Ballard on November 5th, or was it like days prior when you had that conversation?
That day.
Okay. And how did she react to you? Without telling me what she said, like, did she agree with you? Was she angry? How did she react emotionally to you?
She agreed.
From the other court state, she agreed. That is seriously. That's not a court, that's the.
So you can rephrase the question.
Let me ask you this way. After you had that conversation with Ms. Ballard, were the two of you still getting along at that point, or was there conflict between the two?
Are you referring to on November 5th?
On November 5th, with the initial conversation where you tell her that you don't want Mr. Rollins in the house.
We were still getting along.
Okay. Now, at some point on November 5th, or 4th, I guess, because we're also talking about around 11, 12 o'clock on the 5th. Do you see Mr. Rollins attempt to get inside your home?
Yes.
Okay, so do you know about what time that happened?
Between 11:20 and 11:40, I think, not sure.
All right, so between 11:20 and 11:40 at night?
Yes, at night.
All right, so technically this would be then November 4th when he attempted to come in?
Yes.
So describe what happened when Mr. Rollins attempted to come in the home.
He came through the side door. My back door is off the kitchen. Me and Takara were in the kitchen. He pushed the door.
Okay. And how did you react when you saw him push the door in?
When he pushed the door in, I reached behind me. There was a knife on the counter. As the door pushed open, I reached for the knife and told him he can't come in.
All right. And what made you grab a knife when he attempted to come in?
Me, at the time, me and her were talking about them fighting. He pushed the door in. It was aggressive. My instinct, I grabbed the knife.
Now, when you say aggressive, what about how he pushed the door and made you think it was aggressive?
He did not.
Okay. And, you know, was he opening the door like normally, or was it like, was he using force?
Upset.
Sorry, what?
He was upset.
All right. So you said you used a knife. What did you do with the knife when you had it in your hand?
I just had it in my hand. I told him he couldn't come in. He wasn't coming in the house.
And did the defendant say anything when you told him that?
He said, tell her to come out here.
He said that to you?
Yes.
So after you had the knife in your hand, you basically had that back and forth. Did he ever actually come into the home?
No.
All right. Now, when this is going down, you said this is occurring in the kitchen?
Yeah.
True?
Yeah.
Do you know where Mr. Williams is in the house?
He started in the living room when me and Carl were talking in the kitchen. He was in the living room, letting us talk. When he heard the door.
Objection.
Right. Let me ask you this way. Did the door open?
Yes.
Did it make a noise when it opened?
Yes.
So after the door opened, did you see or hear Mr. Williams do anything after the door was open?
When the door opened, he came to the kitchen.
All right. And did he have any words with Mr. Rollins when he came to the kitchen?
Yes.
All right. Did Mr. Rollins say anything to Mr. Williams when they're all in the kitchen together or around the kitchen?
Yes.
What did you hear Mr. Rollins?
He said, tell her to come out here. I'm not gonna come in your house, but your girl is not gonna do nothing to me. And y'all are here because my girl live upstairs. So with that being said, tell her to bring her leave the house.
All right, you're saying believe, was he using his first words? All right. Just emotionally, when you saw Mr. Rollins outside the kitchen, you're having this conversation, how does he emotionally appear?
Angry.
Now, I know he said this and you were standing there and Mr. Williams was standing there too?
Yes, at that time he was in front of me.
Were there any direct words from the defendant only to Mr. Williams?
Yes,
Okay. What did he say only to Mr. Williams?
he told him, man, tell her to come out here, referring to Tara. He said, I won't come in there if she come out here.
Now, during this back and forth, did you hear any threats being made between Mr. Rollins and Mr. Williams?
Mr. Williams told him, that's between y'all, she can come out there. It's my girl house, you're not gonna be here. That Tara being intervened.
All right. Now, when you say she intervened, what did you see her do when you say she intervened?
The men were kind of chest to chest. So now I'm kind of grabbing Ron's arm, pulling back toward me. She came and she
So can I just ask where this is?
standing all in the doorway. She stepped and pushed him all the way back out into the hallway. And it was.
When you say him, you're talking about Mr. Rollins.
Yeah.
All right. Now, when you said that Mr. Williams, Mr. Rollins are chest to chest, did you see any weapons in Mr. Williams's hands when this was happening?
No.
Okay. Did you see any weapons in the defendant's hands when that was happening?
No.
So ultimately, Mr. Rollins and your cousin, Miss Ballard, they went upstairs into the upper flat?
Yeah.
Did you go upstairs too?
No.
Did you see Mr. Williams go upstairs?
No.
What did you do after they went upstairs?
We closed the door.
The door to the upstairs area?
The door to the kitchen where the altercation was.
Okay.
Back there.
After you closed the door, did you go anywhere else or go outside?
We went at that time back into the room.
Okay. Now, when Miss Ballard and the defendant went upstairs, could you hear any noises coming from upstairs?
Yeah.
Describe what you heard.
Sounded like bumping, throwing things. It sounded like they were fighting.
Okay.
Or then we thrown stuff into it.
Did you hear any voices at the time? Or?
Muffled, I couldn't really make out with it. Just yelling.
So after you heard this upstairs, what did you decide to do?
I was ready to leave. At that point, I called my son.
Now, at the point in time where you call your son, was it just you and Mr. Williams in the downstairs flat?
My two daughters were in the room.
Okay, and how old are your two daughters were sleeping?
8 and 12.
Okay. And as far as you know, was there anyone else upstairs besides Miss Ballard and Mr. Rollins?
Not that I know.
Okay. So you said you called your son?
Mm-hmm.
Is that a yes?
Yeah, okay.
And what's your son's name?
John Bradley.
And why did you call?
Because I know the history. I mean, I know things that have happened between them, so I would bring it up. I wanted to,
When you say between them, are you talking about between Miss Ballard and Mr. Rollins or somebody else?
between Ms. Ballard and Mr. Rob.
So you wanted to leave? Is that fair to say?
I was angry
Why were you angry?
because we were asleep and this just came to my door that I was angry that he pushed my door open. I was angry that they were like arguing around me. I was.
So after you called your son, did any other family members or your son ultimately arrive at the address that you're at?
I called my son, but before I ended the call with my son, by that time, Brian had kind of, hey, we good, it is what it is. He was,
At this point, Judge, I'm objecting to this.
Sustain.
So now tell me what was said between you and Mr. Williams. You said earlier that was Ron like upset when he was chest to chest with Mr. Rollins?
he was upset in that moment, but then he was calm and calm with the situation.
Are you saying, so there's quite a time where he eventually became calm. Was it while you were waiting for your son or to arrive?
It was while I was on the phone with my son, so I ultimately told him not.
Okay. So, even though you told them not to come, did any family members show up at your address?
Yes, they were around the corner, so.
So how long do you think it took between when you hung up with your son and when some other family members arrived?
Maybe 8 minutes.
And the other family members of yours who showed up, who were they?
With my children. So all of my children.
All right, so you mentioned 2 children that were sleeping. Did they get awoken when all this was going on?
They were, they were waking up.
Okay. And what are their names?
So my children are in the house.
Yes.
Daria Bradley and Mia Bradley.
All right. Now, the other children came, who didn't start out at the 9776 address. What are their names then?
Ade Bradley, John Bradley, Deon Bradley.
All right, and
Jalen Bradley.
are 2 of them men and 1 of them women? What's the gender of your kids that?
2 men, 1 teenager, and one.
All right. So when they arrived, did they come inside the address?
No.
Did you meet them outside?
Yes, I went outside.
All right, and when you were outside, did you ever see your cousin, Miss Bradley, and or the defendant come outside too?
Miss Bradley was outside, she never came in. Cara came outside.
All right, so you say Miss Bradley, you're talking to your daughter?
My daughter. Yes.
Okay. She came into the home?
No.
Okay, she stayed outside.
Yes.
And
No one came into the home.
And then this Takara, Ballard, did she come fully outside the home?
She came outside.
All right, and when she came outside, was the defendant with her?
Yes.
What happened when they came outside, when you're outside with your kids?
He, the defendant was at the top of the driveway by his car. Takara, she came for us, and she was saying,
Yes, Sustain.
So, when Miss Ballard came outside, did you see any sort of confrontation between your daughter and Miss Ballard?
Yeah.
All right. Now, this confrontation that happened, was it physical or just verbal?
Verbal and physical.
All right. And how long were both of them outside before they started getting into a confrontation?
Couple of minutes.
And when you say physical, like what did you see the two of them do? Punching each other?
Yeah.
All right. And was anyone else involved in this fight besides your daughter and Miss Ballard?
No, the boy were trying to break it up, trying to separate them. We were trying to separate.
You say the boys, who specifically are you talking?
Tejan, Keon, Jay.
All right, so was Mr. Ron Williams outside when this was happening?
Yeah.
What was he doing during this fight that was going on?
He wasn't down with the fight, he was up at the top of the driveway.
All right, so when he's up at the top of the driveway, you've already described that Mr. Rollins had been there earlier. Is that true?
Yeah.
Was he still up there when Mr. Williams was up there too?
Yeah.
What did you see what Mr. Rollins was doing about this fight?
No.
And so both the defendant and Mr. Williams were not involved in this physical altercation.
No.
All right. So how long would you say that this physical altercation went on for before it was broken?
Broken up, and then they were arguing again. So it was broken up a couple of times. Seemed like a long time, but it was just
So after, what did you do as this argument and confrontation was going on?
I was also arguing with her after she was fighting with my daughter. Now I'm arguing with her.
Is this just verbally or were you physical with her too?
It was verbal.
Okay. When you're arguing with your cousin, Ms. Ballard, is the defendant getting involved in that at all? Okay. So at some point you decide to leave the argument or step away from the argument you're having with your cousin.
The boy had at that time got the girls in the car. They got the girls in the car. They were putting us in the car. We were gonna leave. Carl was still talking mess. But it was kind of starting.
All right, so your intentions are to leave. So are you actually in the car or standing next to the car? Where are you?
I was standing next to a car.
And is the car parked in the driveway or someplace else?
It was on the street.
Okay, so it's in the street. Is that true?
Yeah.
Is the car parked across the street from 9776, or is it on the same side of the street as 9776?
Same side.
All right. And is it directly in front of 9776, or is it like down the street for?
A little down the street.
So is it actually in front of a neighbor's house, or is it still in front of 9776?
No, it was in front of the neighbor's house.
Okay. Did you see, while you were standing by your car, did you see Mr. Williams at that time?
At that time, I couldn't really see.
All right, did there come a point where you were able to see him?
Yeah.
Did you see him doing anything with anyone else when you caught sight of him at this time?
No.
Did you ever see him get into an argument with anyone?
No.
Do you remember being interviewed by the police?
Yes.
All right, you remember that ultimately, what you told the police was reduced to a written statement. Remember that?
Yeah.
All right. Do you remember ever telling the police that you saw Ron and Mr. Rollins arguing with each other?
It wasn't though, right, as I was saying.
Okay.
It was, a little bit after. So everyone's now at the car, I'm at the car. From the car point where I was at, I couldn't see. It was dark, it was the angle, I couldn't really see. So now everybody is about to go their separate ways. Now I'm looking and I leave the car.
Okay.
When I leave the car, now I can see, I can hear them, but I can see the exchange.
All right, so let me stop you here. Where were you standing when you saw this exchange that you described?
Kind of on the sidewalk, a little in front of the neighbor's house.
Okay. Now you said it was dark outside, but you were able to see Mr. Williams despite the lighting?
Yeah, I could see, I knew it was him and I could see this, like I could see.
Okay. Now, were there any bushes or trees or objects in your way that blocked your vision between where you were standing and where you saw Mr. Williams?
No.
Okay. So describe what you saw Mr. Williams do, or who was he with when that was going on, the exchange?
He was Mr. Rollins. Mr. Rollins was in the driveway, on one side of his truck, Mr. Rollins' truck. Brown was in the driveway on the other side of the truck, closer to the house. And they were kind of, they were getting loud, and they were getting loud.
Now, when you say getting loud, like, did you actually hear what they were saying, or
No,
did you hear any words being said? Like any voices, or no?
some cousins, that both of their voices.
And in terms of like their body language, were they face to face with one another?
Yeah, face to face, but on opposite sides with the.
In terms of like how they were standing, did it appear to you that they were being aggressive with one another?
Yes.
What about how they were communicating or standing led you to think that?
Standing at each other, check out. That's the saying. You're yelling.
You say like a stance, are you talking like an aggressive stance? Okay. So you saw the two of them having this exchange. What did you see happen?
I saw them having the exchange. I kind of scoured where everybody else was. When I saw them having the exchange, I ran.
All right, and you ran over to where they were?
Yeah.
Why were you gonna run over?
I was angry. I was trying to get Ryan. I just ran for it. I was trying to grab him, like we're really.
And what happened when you tried to run to where Mr. Williams was?
I'm not sure if I fell or if Ryan pushed me. I'm not sure, but I fell. I went around.
Now, when you say that, you either fell or Ron pushed you, are you close enough to where you can maybe touch Mr. Williams? Did you get that far to him?
I got close.
Now, when you got that close to him, did you see whether Mr. Williams had any weapons in his hands?
Mr. Williams?
Yes.
He didn't have anything.
Did you see if Mr. Rollins had anything?
I wasn't looking.
Okay. So you fall down, and what happens when you fall down?
When I fell down, or when I'm on the ground, the boys, and the boys, and John and Keon, they're dragging me, they try to get me up, but my knee was twisted, I couldn't stand. So they dragged me, from the driveway to down to the sidewalk back to the park.
Okay. When you're being dragged back to the direction of your car, do you see or hear anything at that time?
Gunshot.
Oh. How many gunshots did you?
I didn't hear it. I thought I heard a few. I thought that I heard like three.
Okay. So when you first got close enough to Mr. Williams, when you fell down, was there anyone else besides you three in that area when you fell down?
When I initially fell down, me and Ron.
Sorry. Was it you, Mr. Williams, and the defendant? Is that what you said?
With the initial fall down,
Yes.
yes.
All right.
So I'm sorry, I understand that response.
She said, Mr. Williams, there.
Just fell down, fell down.
Sorry.
I didn't hear what you said.
At the point in time where you fell down, where you were next to Mr. Williams, who was physically in that immediate area when you fell?
Right there next to
Yes.
me and Ron and Mr. Ron.
And when you got pulled back, did you see anyone else go to that area where you would see Mr. Williams and Mr. Rollins?
As they're, when I'm down, the kids, kind of all ran over there.
Right, and then they were able to pull you back all the way to the sidewalk, right?
Yes.
So when you're back at the sidewalk, do you see anyone else in the area where Mr. Williams and Mr. Rollins were, other than the two of them? So you said you heard gunshots. What did you do when you heard gunshots?
I was still trying to land back now, trying to toward the car, because I couldn't get up. Everybody was kind of scattering. When I kind of focused in, I'm looking, because I can see where everybody else is going, but I don't see one. So now I'm very like, where? It was chaotic. I saw Ron in the driveway. And got all a little bit.
So you saw Mr. Williams in the driveway area? Was he still in the same area around the cars that you described him earlier? And did he have any current injuries to his body?
I didn't, when I first got to him, he was laying on his stomach. I looked him over, I couldn't see, I rolled him over. I just remember saying, like, where did he get where it's hit? So initially, I didn't see, I couldn't tell.
Eventually, at some point, you see if he, had any wounds or injuries to his body?
I didn't see any.
Did he? And was he moving at all?
Yeah.
Okay. Was he still breathing when you first got there? Now, when you're going to the area, and you managed to crawl up where Mr. Williams was, did you see Mr. Rollins anywhere?
He after the shot, he jumped in the truck and backed out.
All right, so how soon after the shots were fired did you see him get the car and drive away?
Immediately.
Did you see anything in his hands before he drove away?
I grew up.
Okay. Now, know, did you yourself or did somebody else ever call 911?
Yeah.
No. When you're around Mr. Rollins and Mr. Williams' body, you see guns, knives, weapons in his hands or around him at all? And did police or ambulance ever show up at the address? How long did it take to get there? You know?
There, we quite a long time, but it probably were there within 5 minutes.
All right, and so did you and all your children stay there until the police got there?
Everyone was gone because my daughter, my oldest daughter, shot at red.
So Miss Ballard stayed there the whole time, is that true?
Yeah.
And then your daughter, Miss Bradley, stayed there too? Now, the kids that left, where did they go, you know?
I didn't know that they had my baby.
Now, did you see, so now we're talking about your 2 boys and then the 2 small children, they left? Did you see any of them shoot Mr. Williams? Did you see Miss Ballard shoot Mr. Williams? Did you see your daughter, Miss Bradley, shoot Mr. Williams? Did you shoot Mr. Williams? Did you ever see Ron get into any sort of argument or confrontation with anyone prior to being shot? Like while you're all outside, did you ever see him argue with anyone other than the defendant? I don't have any other questions.
Cross-examine.
Speaker. You were interviewed by the police a couple times, correct? And in fact, one of them was videotaped. You were that.
The night of it.
And you had a statement which you signed, a 3-page statement. Do you recall that? And today you're testifying. Now, when you indicated that the apartment you live in, you live on the time of this incident, you were living on the 1st floor, right? Your cousin was on the upper floor, right? And to get into the upper floor, you don't need to walk through your apartment. Is that true? So you can go upstairs without going into your apartment, correct? And you indicated that during this time, you indicated that Mr. Rollins attempted to get in and grab the gun. Do you remember that testimony?
Yeah.
So you called the police right at that point to be careful?
No.
In fact, you didn't keep that knife with you at all after that. You just kept it in the kitchen, right? You just put it right there, right? And in fact, Mr. Williams didn't even wake up from his kitchen, right? Okay, but was he in the kitchen? This time, when you had this knife in your hand, Mr. Williams in that room? And so now you indicated that Mr. Williams comes downstairs and you told us in detail about this chest-to-chest confrontation. Remember that testimony?
He didn't come downstairs, but I guess he was in the doorway.
Right. You mean who?
Mr. Rollins
And
Mr. Williams.
and this is what you're telling us, Judge, today, that Mr. Rollins and Mr. Williams chest to chest, right? And doesn't that suggest a confrontation of some sort?
That was just, he was telling him he's not from there.
Chest to chest was your description, right? And you remember that, right?
Yeah.
And when you made your statement, your 3-page statement, you didn't mention that at all. You didn't even say anything about chest to chest. Does that surprise you?
No.
So wouldn't your memory have been better back in January? November 5th, 2017?
But it will say
Hold on a second,
that
hold on. Wasn't your memory better right after this incident than it is today?
No.
Your memory gets better and better?
Yes.
So years and years later, your memory gets better and better?
from this incident, from dealing with something in the moment, something traumatic, then I have to remember more. But in that statement, it will say that they were in the doorway.
Okay, there's nothing about chest to chest, right? Okay, and you remember such details. Do you remember what your words were in your statement? What were your words in the statement?
I don't know.
Okay. She says her memory is better. All right, I'll move on. Now, now you said you called your son. Is that? I'll say that's.
Yeah.
But then you told him not to do it, right?
Yeah.
Because you didn't feel there was any need, right?
Right.
Because you didn't think it was such an issue or a problem for him to come over. In fact, you told him not to do it, right?
Ron was there, he said.
Yeah, no, that's the question. You told him not to do it.
Absolutely.
Now, at some point, Mr. Rollins goes to his trailblazer, his vehicle, right? Yeah, he's going to his car, not to Mr. Williams' car. He's going to his car, right? So yes?
Yeah.
And Mr. Williams goes to that car.
Well, the car is at the door. If you walk out of the door, you're at the car.
Okay, so Mr. Williams leaves and goes to the car outside the door, which is Mr. Rollins' car, right?
He did not go to his car.
He goes to Mr. Rollins.
He goes outside.
And Mr. Rollins is outside.
And so is everyone.
Well, I'm not asking about everyone else. Mr. Williams is going up to Mr. Rollins. Isn't that true?
What's the question?
Isn't Mr. Williams going outside and approaching Mr. Rollins?
No.
Well, Mr. Rollins is outside, right?
Yeah.
And Mr. Williams is not outside, right?
We were outside together.
Okay, and then Mr. Rollins is near his vehicle, the trailblazer, correct?
We were
Is that
outside
correct?
for Mr. Rollins.
Is that correct? Mr. Rollins is near his trailblazer. Yes.
Yes.
And Mr. Williams then goes towards that trailblazer. I shouldn't ask that answer.
She said that he did not go to Mr. Rollins.
Now, you never see Mr. Rollins with a firearm or weapon of any type, right?
No.
Like the only person that had any kind of weapon you saw was yourself with a knife, right?
Yeah.
Now, you said that you're so close that I think at some point you said you thought Mr. Williams may have pushed you or something. You fell or you might have kind of pushed.
Fell or I was pushed.
If your statement only says that I slipped and fell, it doesn't say anything about thinking someone pushed you or Mr. Williams pushing you. Is that, you forgot that part? Why is that not in?
Because after, as more comes to me and talking to people, I'm not sure. I feel like I felt there was a ditch. If you look, if you go and take pictures on the grass right there, there's like a hole. I ran toward, I fell. It's possible that I was pushed.
You don't mention being pushed, or you don't even mention who might have pushed you in your state. Would you agree? Would you agree?
I would.
Now, you said your daughter and her had a state argument. You said it was a physical argument, right?
Yes.
But
Yeah.
in your statement, you didn't say physical, you said verbal argument. Remember that? You didn't say anything about physical.
Okay.
Is that true?
That may be true.
So was it true or not true when you said verbal?
They had a verbal altercation and then they started swinging.
But you never said anything about swinging. Did you? Is that because
Maybe not.
your memory's getting better?
Yes.
Now, when you your children that came to the location, they didn't stay location even after his wound is on the ground, so they leave before the police or ambulance arrived.
No one knew at the time that someone was on the ground.
Okay,
You hear a gunshot, you run, that's what you do.
so you ran also, right?
I couldn't run.
Your sister ran also?
My sister wasn't there.
I mean, cousin. I'm sorry, cousin. You know what, the cousin, my sister cousin.
Or
Did she run also, but gunshot?
I wasn't looking for her.
I thought you testified. Her statement.
I'm sorry.
I thought you testified.
No, the car was there. He asked who was there after when Brown was on Brown, I was Savon. The car was there. She didn't have a car to run to get into. He pulled out and left her. Oh,
Your children left the scene. Your adult children left the scene.
yes, I
Right?
did.
Mr. Williams is on the ground when they leave the scene. Right? Yes?
Yeah,
And they don't stay there to help you or help him, or they took something or left something, we don't know. They just left, right?
they left me.
We have no idea what their interaction was with Mr. Rollins. do we?
Objection causes speculation.
Let me rephrase it. When Mr. Rollins and Mr. Williams are having this argument, as you described. Remember that? Yes.
Yes,
Your adult children are right at that scene, right at the location, right?
at the location.
And they're your advocates, they're kind of on your side, would you agree? So how many people were there other than Mr. Rollins outside? How many were adult children? You've been named before, just give me the name.
Section, Sade. Jay,
What about, Hazel? So 4 adult children? Yes.
Yes,
And Mr. Williams?
yes,
They were all outside, and is it true that they were confronting Mr. Rollins?
no, they never said you.
They were just quietly sitting there, or you were told?
They were upset with the car.
And what was this argument about? What was the argument?
With
No, sorry, between, you described between Mr. Williams and Mr. Rollins. Do you know what this argument was about?
Before the argument began, he originally was being actually tied to her. So we were, so that was the initial argument.
But, this argument with Mr. Williams, and Mr. Rollins, Farah was not involved with this argument. Is that fair to say outside the car, in that thoroughfare? She wasn't involved in that argument.
Was she up there with them? No, she was not.
Did you hear any pause between any shots?
Oh,
Yes, pause. You know what pause is, like the time?
argument started again.
Yes, like the lapse of time. And you said when Mr. Rollins jumped immediately to his vehicle, that was immediately after you heard the shots. Remember that testimony?
Yeah.
And you never saw a firearm in the session? And you actually never saw the shooting, correct?
Then he actually shoot.
How many shots did you hear?
I thought I heard 3. I know that I didn't know.
I didn't know.
Because now I know from other information like that he actually shoot. At the time, I thought I heard a few shots. I didn't even think anybody was hit. So,
But when you made your statement to the police, you remember what you told them? Do you remember?
No.
You don't remember what you told the police, how many shots?
no, 3 or 5.
Said a lot fell from. Did you actually know Mr. Rollins' name?
No,
You didn't know his name?
not never officially met him before.
Did you ever see the adult children that you described jump or attack or have any contact with Mr. Rollins outside next to his house?
No.
When you slipped and fell, you twisted your ankle?
90.
When you made your statement, didn't you say that you saw Mr. Williams standing in the driveway arguing with Kara's boyfriend?
Our boyfriend.
So it was Mr. Williams arguing with Kara's boyfriend, which is Mr. Rollins, right? Yeah, you didn't say Mr. Rollins was arguing with Mr. Williams.
They were arguing. I don't know him, so I'm going to speak for the person.
You said Kara's boyfriend, you know how to describe it.
Yeah.
So it's not an issue of description. You said that you saw Mr. Williams standing in the driveway arguing with Kara's boyfriend, right? Is that true?
Yes.
You ever see the two sons, Keon and his aunt, walking up the driveway toward where Ron was and the Rollins was? See him walking in that direction?
No.
That's not my question. Did you see them
They
walking?
walking.
Because you
Yes.
saw them walking up the driveway towards where Ron and Mr. Rollins was.
Yeah.
And then after that is when you heard the shots, right?
After they were in the driveway.
After you saw your two sons walking up the driveway towards Mr. Williams and Ms. Rollins, that's when you heard that.
It was after the.
So about, do you have any idea why they didn't go up that driveway?
Because now people are arguing.
Oh, really?
No, those two were arguing.
So that's why the two, all walk up that driveway towards the other.
Yes.
Who took you to your car? How did you left? How did you? Someone take you to the car? Right? What was, how did that?
How did that leave? The scene?
Yes.
How does it leave?
No, you said you didn't drag some.
Oh, to a car, was it? It was a car. It was the car that my daughter was driving, which is why she was still.
Who took you to that? Who did that?
Was right there.
Yeah.
Patient, yeah.
All right, nothing else, Judge. Thank you.
You hear it?
No, Judge.
Thank you, ma'am. You may step down. How many more witnesses do you have?
That's it, Judge.
Okay, any witnesses for the defendant?
Hang on.
People?
Your Honor, I would like to turn it over and reserve it.
Also, object to the line over. I understand the testimony. The court has heard many such cases. The question is there probable cause? She's obviously the shooting. It's all circumstantial at best. I can make a lengthy argument and repeat what she said and what she didn't say, but the elements of probable cause and establishes our objection based on her, what she said and what she didn't see, for speculation, for extending this motion. The question is there no probable cause?
Judge, it's a matter of civil deduction. There was testimony that of the people who were outside is the defendant and the decedent who are the ones arguing with each other. Nobody else had any sort of hostile posture towards the decedent. And then you have the testimony that none of Miss Mayberry's children shot the victim. Miss Ballard did not shoot the victim. The only other person in the area is the defendant. It gives rise to a circumstantial inference that the defendant is in fact the person who shot the decedent. And then you also have the defendant's actions after the fact, where he immediately gets in his car and drives away, while most of the other people at the scene, aside from some children, stay on scene. So I think by probable cause standards, there is a sufficient evidentiary basis to find this case on the circuit court.
Okay. So quite frankly, it looks as though the only issue on these has to do with identity. Quite frankly, given the number of gunshot wounds that the complainant, Mr. Williams, sustained, who's ever responsible for this murder should probably be charged with first degree murder. Premeditated. It chose to charge second degree murder instead. If you have a stipulation as to count two,
Yes, sir, the beginning example was.
Just remind me of two exact numbers.
so,
Yes.
okay. All right, so people has presented a very circumstantial case. Circumstantial is that this is going to be that it's bad. Many instances, circumstantial evidence can be more potent than direct evidence. I think given the totality of the circumstances, have met the urban problem as it relates to charges contained in the warrant. The witness testified that although she didn't see anyone with the weapon other than herself on this particular occasion, that it was the defendant and the plaintiff witness, Mr. Williams, that were involved in some kind of argument or disagreement. Shortly thereafter, shots rang out. No one else is in the area but them. And then the defendant leaves the area in the vehicle. Court recognizes that this circumstantial evidence combined with the to Lake County Third Circuit Court Criminal Division proceedings is arraigned on the information date and time will be January 25th, 2024 at 9:00 a.m.
So what was the other? Sorry, what did you say the AOI is?
January 25th. January 25th at 9:00.
For DSU.
I will.
Okay, thank you, Judge.
Thank you, sir. Thank you, sir. Everybody here for our 11:30 yet?
Yeah, I think everybody's here.
Okay, great. Thank you. Everyone good? All right, go ahead. everything is down on me at once. Everybody, Mr. Smith?
What's your name, sir?
Jason Smith.
Go see what
You ready?
is that?
You ready to do that?
Yeah, yeah.
Okay, ready? Are we ready on Smith, guys?
Yes, I am, Judge.
Excuse me. Mother she's got a hospital. She has or my hands. Sir.
Calling case 2359351, people of the state of Michigan versus Jason Deshaun Smith Jr. Defendant charged with count 1 felony murder, count 2 homicide, murder, first degree premeditated, count 3 armed robbery, count 4 felony firearm, count 5 felony firearm, count 6 felony firearm. Appearances for the record, please.
Good morning, Your Honor. Anna Bickerstaff on behalf of people, PH 215.
Sorry.
Yes.
I wasn't listening. Judge, good morning. Michael Woodyard, my number is 64612. I'm a staff attorney with Neighborhood Defender Service of Detroit. We represent Mr. Smith. He's here in court. Say good morning and say your name.
Good morning, Judge. My name is Jason Deshaun Smith. All right, designate time set for preliminary examination. Are we ready to proceed?
Yes, Judge.
How many witnesses will be?
4 potentially.
Do you have any preliminary matters before we call witnesses?
Yes, Judge. At this time, people would ask for a mutual order of sequestration for the excitement to my officer in charge. You see the 21.
No objection to the OIC. All right, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. It doesn't appear to be any other people in the courtroom.
Oh, I'm sorry, Judge. I would also ask for an exception for the victim's sister, Miss Marianne Sprout, who I do believe is viewing on YouTube. I would just ask for an exception for the proceedings also.
Is she a witness?
She would just be an identifying witness. She would have no other testimony outside of the identification.
That's fine.
Judge, can I have just 1 minute? I apologize. Mr. Smith's mom is in the hallway. She anticipated coming in, but it may be that she would be sequestered. So I'm just going to go let her know that she can't come. Okay, thank you. Judge, I'm sorry, we're ready, just so the record's clear. The issue that I had thought might be an issue is not an issue. It's not. Judge, thank you.
All right. Anything else?
Judge, I have spoken to defense counsel. I believe the stipulation the IP was Patrick Higgins.
We will send it. Court receives that stipulation. Now, are those sunglasses?
Judge, can you approach for a moment?
Sure.
This time the people would move the admission of people's proposed version. Number one, which is a medical examiner's report. Authored by Dr. Jennifer Swatak of the Oakland County Medical Examiner's Office dated September 14th, 2022.
We'll have no objection.
I'm sorry, that would be Dr. Shauna Bryant. Medical Examiner's Office indicated based on the findings and history available, Patrick Higgins, a 62-year-old male, died as a result of a single gunshot wound to the back. The manner of death is homicide.
Judge, I have no objection. I just want to clarify, it's open.
Correct.
Okay. All right. Court receives that stipulation.
People have no other preliminary matters at this time.
Call your first witness.
Thank you, Judge. At this time, the people will call Rihanna Williams to the stand.
Please give your name and spelling to the young lady seated there. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Thank you. Please have a seat in the witness box right next to you. Voice up nice and loud and speak to that microphone is to the left. Check, you pick that up and place it in the left so okay?
No, I'm sorry, you just have one other preliminary matter I wanted to place on the record.
Okay.
I did notify defense counsel 14 days ago that I do intend to introduce a full report of the evidence of the examiners for the defense counsel.
We were so notified, Judge. All right.
Please state your name for the record. Brown Williams. And Ms. Williams, back around September 3rd of 2022, were you dating a boy named Corey? And what's Corey's last name?
Please speak into the microphone. I can't hear you.
Sorry. And how long have you been dating for? And were you hanging out with Corey back on the night of September 3rd of 2022?
I don't see you speaking into the microphone.
Yeah. I can take this. Should I approach to grab the papers, please?
Yes.
And where were you hanging out with Corey on the night of September 3rd of 2022? Were you on foot, in a vehicle, in a residence? Where were you? I was in a vehicle. What kind of? 2019 Chevy. And whose car was that? Who's driving? Me. And where was Corey? At some point, you said Corey was in a house? At some point, does Corey come out of a house? And where does he go?
I cannot hear you at all.
He goes in the driver's seat and I go in the passenger seat.
And what happens when you get to the car? And at some point you stop? At some point you stop driving around?
Yeah, he parked. He goes from the house.
And what happens after he parks in front of that house? Who?
JD.
And do you see where he comes outside from? From the house you parked in front of?
Hold up to the house.
May I approach the witness?
Right.
I'm approaching with people's proposed exhibit number 2. Do you recognize what I have? What have I handed?
A picture of a house.
Okay, which house is that?
This is the danger house. Later down from the house on the North Street.
And is that the house you were parked in front of initially? Yeah. Right. And this time I move for the admission of people's exhibit number 2.
Any objection? No objection, Judge. Admitted.
And when JD comes out of the house, what happens? What happens?
He gets in the car on the driver's side.
Do you see him holding anything? What's he holding?
Yeah,
You got the gun and what?
a big one.
Okay.
When you say face mask, explain what kind of mask. And what happens after JD gets in the car?
Well,
Smoke what?
yeah.
What happens next?
Van pull up, come down the street.
Do you know who was in the van?
A pizza. It was a pizza van.
Oh, okay.
The pizza delivery worker? Okay. And what happens after the pizza guy comes near you guys?
Or if there was just like, this might be your guy or something like that.
And what happens next?
And people were pulling in the driveway behind us. And then he get out of the pizza and give Corey some money for the teachers and the other.
Who gets out?
Okay.
When JD gets out, do you see him take anything with him?
That's a good.
What happens next?
I went up to the teacher and
What happens next?
that's all I know.
Do you hear anything? Do you hear anyone yell anything?
After they came back to the car, I heard the teacher and saying he was wrong with that.
I heard the pizza man say what?
He wasn't wrong with that.
And do you see JD wearing anything at this point?
Yeah, ski mask on?
Yeah.
And what happens next?
Then they went to the car, they gave the car and Corey pulled off.
And does anyone have any pizzas with them at that point?
Yeah.
How many pizzas are that? Now, you mentioned a person named JD, correct? Okay. How long have you known this person? Have you been around him or you've heard of him for a while? And would you recognize him if you saw him again? Do you see him in the courtroom here today? Can you tell me where he's seated?
Can't hear you.
Can you describe something he's wearing, please? This is identified in this case.
So no.
Now, do you recall, after this incident, did you speak with the police?
Yeah.
And then a while after that, did you speak with the prosecutor?
Yeah.
And in speaking with them, did they play you some audio calls? And did you recognize the person's voice in those audio calls? And whose voice did you recognize it as? And would you recognize his voice? Can you explain how was it you were able to recognize his voice? Have you heard him before?
Yes.
Would you say you're familiar with his voice?
Yes.
May I approach the witness?
Yeah.
Play for you People's Proposed Exhibit number 5.
Judge, I wonder, could the microphone be placed next to a speaker so we could all hear it? I can't.
I was going to publish it after I knew that.
She's just laying the foundation.
Thank you, Judge.
All right, were you able to hear the audio recording I played?
Yeah.
All right, was that the audio call that you previously heard?
Yeah.
And do you recognize the voice in that call?
Yeah.
Whose voice is that? At this time, I move to the admission of People's Exhibit number 5.
Any objection?
May I watch your witness? I do have an objection.
What's the objection?
The objection is that the witness is not qualified to offer an identification of voice. Even on this record, I heard the
You
witness.
don't have to be an expert to recognize the voice. It's a familiar voice.
Yes, and what I heard, yes, I didn't hear. I'll explore it on cross-examination.
Okay.
I do object.
Judge, I moved the admission of People's Exhibit 5. I believe I did ask the witness specifically if she had heard his voice before. She said she had. I asked if she was familiar with his voice. She said yes. She indicated that when she had previously heard it, she did recognize his voice. Okay. I have permission to publish the report.
Yes.
Hi, thank you for calling Domino's. Is this for carry out or delivery?
Delivery.
Can I get your address, please?
16557 Lenore.
You said Laverne?
No, Lenore.
Lenore.
L-E-N.
Lenore, okay.
Yep, Lenore.
Yeah, I got it. What can I get for you?
How you doing? Can I get 2 pepperoni and bacon large pieces?
Okay. That be out for you? Hello? Hello?
Mayor Brooks, the witness. Claim for you People's proposed exhibit number 6. We have an opportunity to hear that? Yeah. And do you recognize the voice, or did you have an opportunity to previously hear this call? Yeah. Okay. Did you recognize the voice in this call? Yeah. And whose voice is that? Jenny. At this time, I move to the admission of People's Exhibit 6.
Judge, my objection remains the same.
Permission to publish the report.
Yes.
Thanks for calling Domino's. Is this for carry out or delivery?
A delivery, ma'am.
Oh, you just called. Oh.
Yep.
Sorry, I couldn't hear you at all. 16. You said 16557 Lenore, right?
Yes.
Okay. 2 large pepperoni bacon. Okay. Is there anything
And
else?
on them pieces, can you add extra bacon, ma'am?
Yes.
And that'll be all.
All right. They total is coming to $24.99. Oh wait, you said delivery. Hold on. Let's go bump it. It's gonna be 29. Yeah.
Okay. Would you guys give me a call when the driver is heading out or on the way?
Delivery. Call when on the way. Sure can.
Okay.
All right.
Thank you, man.
Not a problem. Bye bye.
Now, when you also spoke with police, did they show you a group of pictures? Mayor Brooks, the witness.
Right.
Approaching with People's proposed exhibit number 3. You take a look through those. Do you recognize what I handed you?
Yes.
Okay, what am I handing you?
Pictures.
Okay, and are those the pictures the police officer showed you?
Yes.
All right, and did you pick someone out of those pictures?
Yes.
Okay, who did you pick out?
Jay.
And would it be fair to say, when the police officer showed you those pictures, there was no writing on that picture, is that correct?
Yes.
All right, and after you picked it, did they write some questions on there?
Yes.
Okay, what questions did they ask you and what answers did you get?
How do you know JD? I responded, I know him through my ex.
All right, did you also sign that
Yes.
picture? And did you also, put the person's nickname on?
Yes.
At this time, I move for the admission of People's Exhibit 3.
No objection. Admit it.
And permission to publish People's Exhibit 2 and 3 to the court.
Yes.
Now, did there come a time where JD pointed out where he lived? At some point, did you learn where JD lived?
Yes.
Where did he live?
On the Main Street. Well, I knew he came out of the house.
Did you learn that he lived at that house he came out of on Lenore Street?
Yes.
Okay. I passed the witness.
Cross-examine. Thank you. Ms. Williams, good morning, or good afternoon. So you referred to somebody named Corey Stoddard as your ex, is that true?
Yes.
That means that you had a dating relationship with Mr. Corey Stoddard?
Yes.
How long did you date Corey Stoddard?
It was on and off for 5 years.
On and off for 5 years.
Yes.
How old are you now?
21.
When did you break up with Corey?
I don't remember.
Yesterday, a week ago, a month ago, a year ago?
Probably like a year and a half ago.
During the time that you dated Corey Stoddard, it's your testimony that you encountered this person named JD on a couple of occasions. True?
Yes.
He was not, this person JD was not a regular, everyday person who hung out with you in court. True?
Correct.
On this particular day that you described, do you remember the date?
Yes.
What was the date? On September 3rd, this would have been what, the second or third time that you've ever seen this person named JD?
Yes.
Your testimony today is that when you first saw JD coming out of a house on Lenore Street, he had a ski mask on, correct?
Yes.
He had a ski mask on when he got into your car, correct? You said that you and Corey and this person you're calling JD had smoked?
Yes.
And then the band showed up?
Yes.
JD still had that mask on?
Yes.
And this is a mask that covers his face,
Yes.
except for his mouth and his eyeballs?
No, his eyes was only being open.
Okay, so the smoking, how did that happen?
He put me down.
JD was in the back of the car or the front of the car?
The back of the car.
You were in front?
Yes.
Corey was in front.
Yes.
Your testimony was that JD had a gun.
Yes,
You have known Corey to have a gun, true?
yes,
When did you know, were you familiar enough with Corey's gun to recognize it?
no,
You had never seen JD with a gun before that very day, true?
correct.
Is it true that you are not familiar enough with firearms and pistols to say that JD had Corey's gun? Corey was in the house that JD came out of when you pulled up on Lenore, correct?
Yes,
You said that when you pulled up, Corey came out of the house,
yes,
and that's the same house that JD came out of a few minutes later.
yes,
They didn't come out together?
no,
It was daylight?
no,
It was nighttime?
yes.
You remember what time?
Like around 7 or 8.
You were, and you testified that you remember giving statements to the police, true?
Yes,
I'm gonna approach the witness if I may. Okay. Ms. Williams, I'm just gonna hand you this document. Just take a look at it, leaf through, see if you recognize what that is.
it's the same one I gave the police.
Is it what?
It's the same one I gave the police.
Okay, and is that a written statement?
Yes,
You signed that and put your initials on it?
yes,
And if I told you that this was a statement that you gave the police on September 9th of 2022, does that sound right?
yes,
You never said anything about anybody having a gun when you gave this statement, correct?
Right.
And you had been truthful in this statement when you gave it, correct?
Correct.
And you were asked if you saw a gun, correct? You know somebody named GD?
I heard of the name before, but,
You've heard of that name because he was a cousin or a relative of Corey's
yeah, or JD.
or JD?
Mm,
So GD is a different person than JD?
yeah.
Are we using the word cousin in the sense of actual blood relatives or just like cousins? What do you know?
I'm not sure.
So you know that there's somebody whose name is GD who's associated with Corey, and there's someone whose name is JD who's associated with Corey.
Yeah,
Is that your testimony?
yes,
You had never spoken with Mr. JD on the phone, true?
correct.
So when you had met JD, you had seen him in person, face to face,
Yeah.
on the couple of occasions that you saw.
Yes,
You never talked with him on the phone.
no,
You never even heard him on the
I
phone.
heard him on the phone, but I never talked to him.
When this pizza van pulled up, it was on Lenore Street. How far away did it park from the house that you had seen Corey and JD exit?
Two or three houses down.
It's right there.
Yeah,
Same side of the street?
yeah,
Thank you. I don't have to worry about it. Can you redirect?
Yes, Judge. You had testified that you had heard JD on the phone, correct? Is that correct?
Yeah.
Would that be on the phone recording?
Yeah.
But how many times have you heard JD on the phone?
Maybe once or twice.
I have no further questions.
All right. Thank you. You may sit down.
Judge, if this is what the people would call a stand or shirt to the stand.
Ma'am, please step forward, give your name and the spelling of your name to the young lady seated there.
Sir, that's me.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God. Thank you. Please have a seat. This chair next to me. Voice so nice and loud and speak to that microphone to your left. Left. Right. Speaking of placing in your lap, so you can speak directly to the microphone. Thank you. When you're ready.
Thank you, Judge. Can you please state your name for the record?
Sandra, sure.
And Ms. Shirk, how are you currently employed?
I am employed with Domino's.
And were you employed in that capacity back on September 6th of 2022?
Yes.
And which Domino's location were you working at back on September 6th of 2022?
The Livonia Redford location.
And back on September 3rd or September 6th of 2022, was there an employee under your control named by the name of Patrick Higgins?
Yes.
And to the best of your knowledge, Mr. Higgins working on September 6th of 2022?
Yes.
Now, back on September 6th, were you working on that day?
I was not. I was at home during this time.
And at some point when you're at home, do you get a call?
Yes, being the boss, I usually get calls a lot about different things.
And who was the call from?
I got a call from Kendra Jordan, who was the night manager there, about the situation.
And what happened after you got that?
I got a call and she informed me that.
Then my objection, of course, is suspended.
Just people wouldn't be offering food to the parents just for what this did. That's what you received. You received a call, correct?
Yes.
What do you do after you receive that call?
I went to the store.
What do you do after you go to the store?
I monitored the driving app that we have, and we were closing down at the time, and we ended up visiting the location and finding Pat's truck there, and we called the police.
I'm just gonna kind of back up and ask some more questions, okay? About what time do you get the call from the night manager?
Well, we weren't close then. I can't say for sure when I got the call. But I know that Pat was on the road for over 45 minutes, which is basically a security monitor. Like, we want to make sure that everything is going smoothly, and Pat didn't respond to his phone call from Kendra that I got a phone call.
What time does the store close?
We close at midnight.
Now, you had mentioned a way to track you were looking at a tracking system, is that correct? Can you explain that system and explain how it tracks the driver?
So the drivers log into the app, and whenever they leave out on a delivery, it gives them, it gives us the chance to follow the driver to their location of their delivery. And when they complete their delivery, their name changes to a different color, so we know that they're on their way back.
And aside from you and store employees, does anyone else have the ability to track these drivers as we make deliveries?
The customer can track them as well.
And would this be through an app or a website or both? Now, can you explain the store policy on delivery drivers making runs? So would they make one run at a time, or should they make multiple? Explain how that works.
So we want to do good customer service, so we want to have deliveries as singles as much as possible.
When you say singles, what do you mean?
One delivery per person per run.
So the driver would be going to this location from directly back to the store,
Yes.
correct? They wouldn't be making going out making 5 deliveries.
No.
Now, you have mentioned that you came into the store and you were looking at the tracking system, correct?
Yes.
Do you recall what time that would have been?
It was a little bit before close.
A little bit before midnight?
Yes.
And in your system, has the color changed for past me?
Yes.
Now, may I approach the witness? When I hand you people's proposed exhibit number 4, do you recognize what I've handed you there?
Yes, this is the delivery receipt.
All right, does that fairly and accurately depict the delivery receipts that your Domino's was using back on September 6th of 2022?
Yes, we still use them today.
All right, this time I move the admission of people's exhibit number 4.
No, Judge, no. Admit it?
And permission to publish to the jury?
Yes.
I'm sorry, the court, sorry. Ms. Shirk, are you able to see the phone number that placed that order on that receipt?
Yes.
Okay, and where would that be located on the receipt?
It's on the right-hand side of the receipt underneath the address.
All right, and can you read us the number that placed this order?
313-356-2733.
And are you able to see what time the order was placed?
Yes, 10:02.
And at the top of the receipt, can you explain what that is at the top? Would that be your particular store?
Yes, so the top of the receipt shows our address and our phone number, the date and the time, and then the D marks delivery.
Now it says 9:50 at the top. Would that be the time the order was placed?
Yes, so the delivery was placed at 9:50, and the bottom time, the 10:02, is when the delivery was it came out of the oven and was ready to be.
And how many items were in this order?
2 items.
Now, if, to your knowledge, does your store save and record phone calls, orders that are placed?
Yes.
Can you
So
explain that system?
So when a customer calls into the store, it prompts them to let them know that they will be recorded for quality assurance. And I don't know exactly where they're stored, but I know that we can access all the recorded lines.
Now, you had told us that when Pat didn't come back, you had someone go out to that location, correct? Did you personally go to that location?
I did not.
Do you know who did go to that location?
Kenneth.
I have no further questions.
Cross examine.
Thank you. Ms. Short, can I look at that document, please, Patrick?
Absolutely.
There's a line right at the very, very top that says rewards code. You see that?
Yes, sir.
Is that a customer rewards code?
Yeah. It's so when the customer would like to add their points to their account in order to get free pizza or any other type of rewards that we offer.
And those reward codes are unique to a customer?
Every single.
Where do you get the information that printed on the receipt? Does the customer tell you their reward code?
Oh, I'm sorry.
Sure. So that receipt has a reward code printed on it?
Yeah.
True. And that reward code is unique to a particular customer?
Not to a particular customer, it's to a particular receipt. So every single receipt that, so say that this gets, they ordered again, they would get a different rewards code to be able to add to their rewards for later date.
So the reward code that appears on the top of that printed receipt is not associated with a unique customer?
Correct.
It's associated with a unique order?
Correct.
Okay. That's all I have. Thank you.
Any redirection?
No, sir.
Thank you. You may step down. Next one, please.
Judge, at this time, the people would call Detective Antonio Carlisi to the stand.
Sir, please give your name and spelling to the court reporter. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Thank you. When you're ready.
Thank you, Judge. Can you please state your name for the record?
Antonio Carlisi.
And how are you currently employed?
I'm a detective at the Detroit Police Department in homicide.
And were you employed in that capacity back on September 7th of 2022?
Yes.
And back on September 7th of 2022, were you called to perform specific duty in the area of 16569 Lenore in the city of Detroit County?
Yes.
And what was it that you would have done at that location?
I was recalled to that location to extract any surveillance video from that location.
And did you in fact recover surveillance video?
Yes.
And for how many different days of video did you recover?
3 days.
Which days were those?
September 3rd, September 5th, September 6th. With different time frames.
And did you make any observations as to the time stamp on that system?
The time was slow by 1 hour and some minutes. I don't know exactly the minutes.
Okay, so looking at a copy of your report fresh recollection?
Yes, I got it.
Oh.
That was off by an hour and 13 minutes to the world clock.
And earlier today, did you have an opportunity to review a video that you recovered from September 3rd of 2022?
Yes.
And did that video fairly and accurately reflect the video you extracted from application?
Portion, yes, sir.
At this time, I would move to the admission of people's proposed exhibit number 7.
Any objection?
Judge, my only objection is relevance. It sounds like the video clip that is part of this exhibit is from the date, not directly, not the date that this incident occurred. It's from another date. My objection is relevant.
You showing evidence of another date?
Yes, Judge, this is going to be evidence of the incident that we heard from Ms. Williams as it relates to September 3rd, the 404 being robbery that people would submit. And then also that video from September 6th, which would be the homicide incident. So
I'll take your objection.
thank you. Permission to publish to the court?
Yes.
For the record, I'm playing at 12:06. I pause the video at 14 minutes and 58 seconds and player. And Detective, earlier today, did you also have the opportunity to review some video you pulled from this location from September 6th of 2022?
Correct.
And did that video fairly and accurately reflect the video you pulled from September 6th of 2022 at 16569?
Correct.
At this time, I move for the admission of People's Exhibit number 8.
Any objection?
I don't have an objection.
Admitted?
Official published report.
Yes.
And for the record, I'm playing at 10:14. And for the record, I paused the video. Detective, can you explain the timestamp that we see here?
The timestamp on top is stating that it's 9/6/2022 and 9:01 seconds.
And what would the correct or accurate time be for this video?
10:14 p.m.
For the record, I received the video. They're pausing the video at 11 minutes and 30 seconds. Pass it.
Detective Carlisi, other than securing video from this location for the dates that you testified to, did you have any other role in this case?
No, sir.
I don't have any.
Can you adjourn?
No, Judge, thank you.
Thank you, sir. You may stay. Thank you, Your Honor.
Judge, at this time, that people would call Officer Brandon Jordan to the stand.
You'll figure it out.
Okay.
Sir, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat. Thank you. You're ready.
Thank you, Judge. Can you just state your name for the record?
Brandon Jordan.
And how are you currently employed?
I'm a police officer with the Detroit Police Department.
And were you employed in that capacity back on September 6th of 2022?
I was.
And were you involved in a homicide investigation in the area of 16557 Lemoore in the city of Detroit County?
Yes.
And in becoming involved in this investigation of this homicide, were you made aware of other incidents that occurred at this location?
Yes.
Can you explain this?
When we arrived at the location, we discovered that there had been previous robberies at the same location within the past 4 or 5 days.
Judge, I guess my objection is to the reference to previous robberies. The notice was related, the notice that the prosecution provided relative to other act evidence was related to an incident on September 3rd. That's also the testimony that the court has heard. I'm not quite sure about other incidents, so my objection is to that.
I mean, it was in the course of his investigation. People do intend to substantively introduce evidence as to September 3rd, but I mean, the fact that there was also a
Let's
robbery.
just stick to September 3rd.
Yes. All right. And in discovering those other instances, was one of those on September 3rd?
Yeah.
All right. And do you recall the Chris Met number of that incident?
I don't.
We're looking at a copy of the police report's refresh your recollection?
Yeah.
May I approach the witness?
Right.
Then help refresh your recollection? And what's the Chris Net report as it relates to the September 3rd incident?
2209-03-0346.
And as it relates to September 6th, going into the 7th, did you respond to that homicide location?
I did.
And can you describe that location when you arrived?
Nighttime, there was police cars. There were a small amount of blood in the driveway of the location, as well as a document.
And did you make any observations as to the home at that location?
Yes, it appeared to be unoccupied.
And can you explain how you came to that conclusion?
At the time, since the Domino's receipt had that address on it, we obtained the search warrant and we executed the search warrant at the residence.
And what did you discover when you executed the search warrant?
That it appeared it was unoccupied.
Now, when you arrived at the scene on September 6th or 7th, 6th into the 7th, was there a victim on the scene?
No.
And where was the victim at that point?
At the hospital,
And what was the victim wearing?
a Domino's pizza uniform.
And you indicated that when you were at the scene, you observed a receipt, is that correct?
Yes.
And based on this receipt, did you gather any information from it?
Yes.
What information?
A phone number that was used to place the order.
And what do you do with that information?
We take the phone number and we do everything to identify who the phone number is actually to.
And were you able to identify who that phone number was registered to?
Yes.
Who was it registered to?
At the time, Jason.
And after running that phone number, do you do anything else as it relates to that phone number or records?
Yes, we go to obtain the phone records to see what who the callers are, and also to try to attempt to obtain an IP address.
And do you subsequently obtain those phone records?
Yes.
And do you review those phone records?
Yes.
And what do you make any observations of the contents of those records?
Yes.
Do you explain what you observed?
Well, Judge, the phone records are hearsay. They're not in evidence. My objection is the foundation.
Only all records are not hearsay, they're not statements as they are. I'm not getting into the contents of the calls, but the after they called me this. On the foundation, he said you could review the records.
Sorry.
What observations did you make in those records?
As far as
Did you make any observations as to entities or business entities that this number had called?
Yeah.
Can you explain that?
there were several different pizza restaurants that had been called.
In what span of time?
Days. 2 days.
And did you also make any observations as to a most frequent or like top called party from this number?
Yes.
Can you explain what you observed there?
The most frequent top call is one with a phone number that was registered to 15.
And in addition to reviewing these phone numbers or the phone records from this phone number, did you review any other phone records?
Yes.
Can you explain what else you did?
In reference to
I guess what other phone numbers did you request records?
records for the on September 3rd or the 23rd. Yeah, so we also obtained records for Corey Stockton.
And did you have an opportunity to review those records?
Yeah.
And in reviewing those records, did you make any observations as to the phone associated with Corey Stoddard's location on September 6th of 2022. What did you do?
Judge, my objection is, the prosecutor is asking the witness to testify about a host of expert type material, cell phone mapping, cell phone records. Perhaps the witness looked at some papers, but he's no more qualified by looking at papers than anyone would be. And so if that person who did the cell phone extraction, who did the cell phone mapping, that person is not here to testify. This witness can't simply testify about what somebody else did and what this witness saw. My objection is that that's beyond the scope of this person's testimony.
And I think I can ask you a couple of additional questions. When you received the records, correct?
Yes.
When you received the records, is there a latitude and longitude position with each call place?
Yes.
So one would just need to plug in the lat and long into a map of sorts?
Yes.
And did you
Which
do
are
that?
leading questions, and also there's no evidence that this witness is qualified to do these things.
Judge, I think the question. Sustained inference, or can you clarify, sustained is to my question, or in testifying to this?
Sustained this to his objection that he has been qualified to testify in that area. Foundation.
And Judge, I would just indicate, I don't know that he needs to be qualified as an expert. He indicated that the records came, which is led to longitude positions associated with calls, and he just searched those preliminary latitude and longitude. He did not himself do the mapping, but he looked at the raw data. So I'm just looking for his review of the data. Not the map and the mapping, but him looking up those latitude and
He
longitude.
can tell us what he did. That's fine.
Okay, thank you. Can you explain what you did with the data for the phone associated with post-op?
I submitted the data to our server surveillance, and as I got the data, they returned the data to me, and I looked at the map and reviewed the location information for that time period.
Did you review the raw records?
Yes.
Did you review the latitude and longitude associated with them? What did you do, if anything, after reviewing that data?
I took the latitude and longitude record and I, on the internet, obtained what the latitude and longitude would correlate to physical record.
And did you do that with the record? You did that with the records associated with the phone associated with the staff, correct? And what, in plugging in that latitude and longitude, did you make any observations around the time frame of September 6th?
And Judge, my objection is that this, maybe that's what Detective Jordan did. That's nothing more than what anybody could. And what we're talking about, though, is that this is a very highly technical field of cell phone data extraction, the engineering associated with the data that's stored by the phone companies. And now we're getting into the mapping. Judge, this witness has not been qualified. So I'm going to
Tell us what you did. What you did with the information that was needed.
That's the hiccup. It's the information that's given to him that we need to have a foundation for. Someone can tell me something about something I don't know anything about. That doesn't mean that I can simply get to parrot what I was told. There has to be a foundation for witness testimony, and that's missing. That's my objection.
What observations did you make from that data from the night time of September 6th of 2020?
That the phone associated with Corey Stoddard was not near the scene of the crime.
Now, did you request any other phone records?
Yes.
Which phone records were those?
The phone records from Text Now was one of the associated cases.
And did you receive that data?
Yes.
And did you review that data?
Yes.
Can you explain what you did and how you reviewed that data?
Similar to the way that I explained with the phone associated with Corey Stoddard, I plugged into the information and.
Sorry, if you don't mind, speaking to the record.
Oh, I'm sorry about that. It's okay. I plugged in the information and associated the information given to me with a physical address.
And did that information cover the time span of the evening hours of September 6th of 2022?
Yes,
And what observations did you make with the data around that time?
that the phone was near the location of the homicide.
And in the course of this investigation, did you also prepare a 6-pack for a witness named Rihanna Williams?
I did.
Mayor, first witness. Maybe both proposed exhibit number 9. Do you recognize what I'm handing you?
I do.
What am I handing?
This is the lineup and photo array identification record.
And you prepared that photo array?
I did.
And who was listed as photo number 3?
Jason Smith Jr.
And which picture did the witness get?
Photo number 3.
This time I move the admission of people exhibit number 9.
No objection. Admitted.
And in the course of this investigation, would it be fair to say that an individual by the name of Jason Smith Jr. became a possible suspect?
Yes.
And did you make any attempts to ascertain that individual's registered address?
Yes.
And what was that person's registered address?
16535 Lenore.
And how close was that from the homicide scene?
Approximately 2 doors down. I believe there's a vacant lot in between also.
Would it be fair to say that the homicide scene and the robbery from September 3rd occurred at the same home?
Yes.
Now, when you first responded to the scene on September 6th, going into 7th, do you observe any pizza boxes at the location?
Yes.
How many?
I recall 1.
Do you recall where that pizza box was?
In the driveway.
Where in the driveway? At the bottom of the street or at the top of the house?
At the top, pretty much where the sidewalk and the driveway meets, in front of the easement. The easement, that front portion of grass.
Cross-examine.
Thank you, Judge. Detective Jordan, you talked a little bit about a phone number that was on that receipt. Remember that?
Yes.
That 5356 number?
Yes, I do.
That telephone number is it's associated with a web-based free phone service, true?
Correct.
That's the sort of phone service that one doesn't need to provide truthful information to get a number.
Correct.
You testified that your efforts showed that the 356 number was associated with Jason Smith Jr.
That it was associated with Jason Smith, not Jason Smith Jr. or Senior.
How did you do that?
When you take the number and we look at the frequent callers as well as the there's an email address associated as well with it.
Say that again, please.
There's an email address associated as well with it, but we also look at the frequent callers, top callers.
So and when you say associated, you mean that, is it your testimony that you sought information from text now related to the telephone number beginning with 356?
Correct.
And the information that you received back from text now included a list of telephone calls that number had made.
Yes,
And it also, is it your testimony, it also included an email associated with that telephone number?
yes.
You have that email address?
No, I don't. I don't recall. I would have to look at it. I do have it, but I don't have it with you.
You don't have it in your file that's present here in the courtroom?
No.
Was it your testimony that the very top most frequently called number from the 356 number was a telephone number associated with Jason Smith Sr.?
Correct.
At some point, you said that the scene where the victim was shot is within 2 street addresses of the home where Mr. Jason Smith Jr. was determined to have resided.
I don't recall the exact amount of addresses. It's 2, maybe 3. I recall a vacant lot that was also in the swing.
Fair enough that if the phone were in the house and the phone were at the scene of the crime, they would be paying off at the same time.
Correct.
Thank you. I don't have anything. Can you redirect?
Judge, I just have 2 additional questions. In the course of your investigation, were you able to draw any association between Jason Smith Jr. and Jason Smith Sr.?
Yes.
What was the relation, if any, that you discovered?
Father and son lived at the same address.
And defense counsel was asking about the phone number from the receipt. Based on that receipt, or the phone number on the receipt, did you make any requests for items from the Domino's store?
Yes.
What did you request?
To see if there were any recordings of the orders that were made.
And were there?
Yes.
And those would have been from from September 6th of 2022?
Correct.
I have no further questions, Judge.
Anything else, Mr. McYard? No, Judge, thank you. Thank you, sir. You may step down. Any other witnesses on behalf of the people?
People have no further witnesses at this time.
Any witnesses on behalf of the defendant? No, Judge.
Judge, at this time, the people would move to bind the defendant over on the counts containing information. Judge, we did first hear testimony from Ms. Brianna Williams, who did testify to an incident that happened earlier on September 3rd, a robbery that occurred from JD, the defendant, and Corey, where they were waiting in the car for a pizza delivery guy. When the pizza delivery guy pulled up, Corey said to JD, "There's your guy." Brianna indicated that at this time, JD had a gun and a ski mask on him that was covering his face. They got out of the car, they got back in the car with pizzas, and Brianna indicated that she heard the guy outside yell, "I want my wallet," or "Give me my wallet back," or something to that effect, Judge. And then in addition to that 9-3 incident at that same location, we heard testimony of this homicide incident happening on September 6th. 3 days after this initial armed robbery, we did hear testimony that the phone number that was used to place that pizza order was associated with the defendant. The phone number that was used to place that pizza order, one of their top callers was the defendant's dad, Jason Smith Sr. We also heard testimony that that phone at the time of this incident was in the area of the homicide. Judge, we also heard testimony that not only did that phone number call this pizza delivery store, this Domino's, but it also called multiple other pizza delivery stores within the past couple of days of this homicide incident. We also heard testimony that the phone associated with Corey Stoddard was not in the area on the night of September 6th of this homicide. We also heard testimony that Ms. Brianna Williams, when she heard the phone calls that were placed by the phone number associated with the defendant, Ms. Brianna Williams indicated that was the defendant's voice. She recognized the defendant's voice. We also heard testimony that there was only 1 pizza left at the location when the order was placed for 2, indicating that some items were taken from the scene and potential other items that were robbed off this pizza delivery driver when he was making this delivery run. So, Judge, I do believe we've heard to a probable cause standard evidence that this defendant was the individual that set up the call. He waited there. This was 2 doors down from his registered address, the location where the other robbery incident had taken place. So people do believe that I've proven to a probable cause standard the elements of the counts containing information. I'm saving time for the
Judge, we saw a videotape, and I think the real relevance, only relevance of the videotape is that there was an indistinguishable type of figure who made their way down the driveway, not down the sidewalk from another address, but down the driveway, and looked as though it had an interaction with the victim in this case that resulted in the victim lying on the ground. Presumably that was it. The witness, Ms. Rayana Williams, she did testify in court today that there was a gun involved whenever her boyfriend and this person were in the car. She also said that she gave a statement to the police, she was truthful to the police, and she didn't say anything about a gun being involved in that incident. I think that the court should look very carefully and skeptically at Ms. Williams' testimony, especially concerning this idea of voice identification. She said that she recognized it. I don't know if you heard when I listened to the call, it sounds to me like there's at least two separate voices that take place in the call. The very first voice and then the second voice, and you can tell the breathing is different, it's held differently, the articulation is different. There's two different voices at least. I think if you listen to it, you'll see that there's a moment when the second voice then even initiates it. Oh, hello, kind of in the middle of the call. I guess my point in this aspect of the argument is that any type of voice print analysis testimony that Ms. Williams is offering, I think should be very skeptical about it. She did say that on some occasions she perhaps heard the person she thinks is JD on the phone with her boyfriend, Curtis Stoddard. And that's it. That's the only way that she's able to say that she was identifying this. And I think that if that is the connection between this man and that murder, my client and that murder, it's woefully or insufficient, woefully insufficient. We've heard testimony about another incident that took place on the 3rd of September, 3 days before this incident. Perhaps Jason Smith was involved in that, according to the testimony. Judge, there's nobody who puts Mr. Smith at that scene. The video doesn't know. If his phone, if this witness who Mr. Detective Jordan, who's simply testifying about what he read, if that's sufficient for this court to really believe that the phone associated with the order was in fact associated with Mr. Smith, if you're prepared to make that leap, you have to also take into account the fact that Mr. Smith lived right there. And so what if his phone was pinging at the scene where this shooting took place? Because it's also the same tower that it would be pinging at if he was home. And there was at least 2 people involved here in the robbery, Curtis Stoddard and Mr. Smith, if you're believing Ms. Williams. I'm not quite sure how. That's not July. September 3rd, 2 days before, correct. So we know that there's at least 2 people who engage in this type of behavior, right? We know that if you believe Ms. Williams. And so they have testimony that Mr. Stoddard phone did not think that his phone didn't. That doesn't mean Mr. Stoddard, where did the gun come from? Miss Williams also testified that she knew Mr. Stoddard to possess a gun. She didn't testify that she also testified that she saw a clip on it. She did see it with a gun. She didn't know if it was Mr. Stoddard's gun or not. She didn't know enough about it to testify. I guess you're right. And that's a question. That's a question. I get that. I would urge the court, though, to remember that probable cause is not just the existence of questions. It's a conviction in your assessment of good faith, conscience, a belief in good conscience that Mr. Smith Jr. is guilty. Not that maybe there's questions about it, but an actual good faith belief that he did it. Not rising. I'm glad you put it that way. I'm glad you put it that way. I believe that it's the standard, and I don't think we're anywhere near it. That's my
All right, so this court is again faced with a lot of strong circumstantial evidence that the defendant is the one perpetrating these crimes. The only thing that I may have issue with is count 2, homicide, murder, and first degree premeditated. How do you get premeditation as opposed to just felony murder?
Just the fact that he asked the delivery driver to call on their way, the fact that.
That's for the robbery.
Yes, sir.
Where do you get premeditation?
I did it in the discussion.
So as it relates to the felony murder, I think there's no question here that felony murder took place, an armed robbery took place, and it was done with a firearm. So with those counts, the court has no issue with. The only issue, if there is an issue, here is the identification of the defendant as the perpetrator of those crimes. The court is not satisfied with the murder probable cause as it relates to count 2, homicide, murder, first degree premeditated. I just don't see any evidence of any premeditation here. So the court will dismiss count 2 for insufficient evidence. As it relates to the identification of the defendant as the perpetrator of these crimes, the court is without any reservation at all that the defendant, I mean, there's just too many coincidences that these pizza delivery men again are getting robbed on the same street at the same location, doors down from the defendant. The defendant's voice was recognized as placing the order using a phone associated with the defendant. And we know that it's associated with the defendant because it pings at the location that the defendant is. It calls the defendant's father. And his voice is identified as making the call. Where these robberies took place just days before this homicide took place. I think we have strong circumstantial evidence here that he is the defendant, that is the perpetrator of these crimes.
It's not my baby. I walk out. Oh my goodness. Another boy lives with us and he did it, and they know that. They know that. They know that. It's not my baby.
Anyway, I should be locking the mother up right now, but I understand her frustration. The court is satisfied that people met the burden of probable cause as relates to counts 1, 3, 4, 5. Count 6 is with the.
I think 5 would be dismissed, Judge. I think
5 is dismissed.
Yes.
1, 3, 4, and 6. The court finding those charges were committed in the city of Detroit. Court finding probable cause to be disciplined. Will bind this over to Lane County 3rd Circuit Court Criminal Division of proceedings. Is arraigned on the information date and time of January 25th, 2024, 9 o'clock a.m. Following continue.
Thank you.
Hey, right. Do that, man. Okay, I'll do that. You hear me? Hey. Hey, shut up.
You might want to keep an eye on
Like what they
the
call her.
I don't know what do that means.
Yeah, thank you.
Peter said, you might want to keep an eye on your witness to testify. I don't know if you heard me when he said do that to whoever it was that was in it. I don't know what do that means. It doesn't sound good.
On this case, the defendant said that to my witness.
No, he said that to what was other sitting in the courtroom. He said, do that, do that. Hey, look at the stars in town. Check him out. I don't know about the star part, but I think I've been in the building for 10 years. We're gonna get started at 2, okay? Because we haven't had a break yet. Okay. I'll tell, Matt. Okay. Hey, Mr. Fisher. That's a fine young man you raised in there. You tell me he was in my class?
He did, he had a ball.
He kind of jumped out on me at the medical examiner's office.
Oh, I told him before we went, I said, Eric, you've never experienced anything like this.
Oh, man, it kind of got to me too, because we had a decomposed body. I didn't realize that the brain turns to mush when that happens, and they can scoop it out, spoon like it was oatmeal.
He called me, he said, I told him, I said, you better hold your breath when you go in there.
He couldn't take it.
I remember back in the day when they defenders, so that's they would take us over there just to see it.
Nice kid.
I did about like, yeah, he's a good kid.
This is here.
Oh.
Downstairs. They already on with it. No, yet. Lawyer's back here. Okay.
Thanks, sir.
What are the attorney?
No, oh, I see.
Okay. Just down to what?
Fourth one, you had a question about this.
Oh.
I have no idea.
Talk about fingerprints? Yeah. Oh.
Still got to send it down. We can talk to him.
Count 2 and 5. Well, do you remember count 2 and 5?
Mr. Forrest, what's going on?
Yeah, just had a question about that.
No.
You looked at the.
What's up, Mr. Forrest?
How are you?
I'm good. How are you? Good.
This is Brown part fingerprint process.
They claim he wasn't. Is there an issue with them? Any fingerprint?
Those not. Yeah, you just saw the process that you see.
I just provided that with the hatchet. So I don't know if you heard me when we started at 2 o'clock.
Yeah. Thanks. Is it the prosecutor?
I'll take this since I'm here. Yes. I can do it.
Where's the recess to?
This round. This round. You can just email it. That's just-
Email.
Yeah, don't worry about it. Thank you. Thank you.
Oh, God, rub it in. Okay, rub it in. First look, what happened to
Yes. Come on up. Thank you.
Oh.
I don't know if they're still teaching. Okay, I need to go to the next one. Okay. Okay, are we ready? Yes. Yes, sir. All right. This is case 2360538 for the state of Michigan versus Jamar Marquise Alexander Brown. Defendant is charged at count 1 homicide, manslaughter, and voluntary. Count 2 common law offenses. Appearances for the record.
Good afternoon, Your Honor. Max Beisels, key 77513 on behalf of the people.
Good afternoon, Judge Steve Fishman and Matthew Forrest on behalf of the defendant. I usually try not to put my P number on the record because it makes everybody know how old I am, but it is 23049. Your feet number, Mr. Forrest.
Good afternoon, Your Honor. Matthew Forrest on behalf of defendant Brown, P73168.
This date, time set for preliminary examination. Are we ready to proceed? Yes, sir.
Yes, Your Honor. I was just asked if I need to be let into the Zoom meeting, so I can leave it.
We'd also move to sequester any witnesses.
All right, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log on at this time. If there are any witnesses in the courtroom, I'm asking you to step out into the hallway until further notice. Appreciate you, Mr. President. You are now the co-host. How many witnesses we have?
The people will not be calling.
We intend to call one, not the elected to two. How are we proceeding?
Through a number of stipulations or the court minute exhibits.
Okay. Go ahead.
The first stipulated exhibit would be people proposed exhibit number 2, which would be body worn camera of the defendant, Officer Brown.
So stipulated for submission. Agreed. Admitted.
And at this time, I would ask to play that video.
Okay.
But we do have a copy of the audio that I think both the prosecution and the defense agree is accurate. The court went back and watching the video.
There's no audio with the video?
There is audio with the video. It's a transcribed audio. The video was sent out to me transcribed. So that would be the type of audio that defense counsel requested.
This is coming out to be very unusual exam.
That's for sure.
And at this time, I'll now play Officer Brown body worn camera, which is from September 1st, 2023. And it's upon his arrival at 4120 Woodward Avenue, City, Detroit. Your Honor, is there any way I could try and plug it in here?
I don't know how to plug into it. That's not something that we're going to do. Can we call IT?
Counsel. Counsel. No, it's a plug in right here. This cord right here.
I was going to call for some assistance with IT.
We got to bring the laptop over here though. Same.
Can they come give us some assistance?
No one will see.
Uh,
If you use TV for it, no one will see it.
can
Oh,
you give us
so-
some assistance?
I guess you'll see it in here, but you won't see it on Zoom.
It's on this way.
In your honor, do you have a remote for the TV?
Yes.
May I approach to use it?
Sure. Well, this one, there's actually two.
Can I both of them?
Yes, sir. You guys too.
I frankly you would have to hang up the Zoom call at this point.
Yeah, the Polycom is taking over that signal right now. So when you hang up Zoom and you disconnect off of Zoom, then this thing will connect the TV. The other option is for connect to Zoom, and then you let them share a screen. You share.
That's what I was trying to do.
Oh, okay. Okay, that's what you want. It's just that's not, that's all. That's what happened.
If I need to, I can walk over. Looks like we're ready.
Okay. May proceed.
Thank you, Judge. And I read it again, right, people.
No. Y'all call. What's up, sir? How you doing today? I'm the police. Oh, I can the police too. Yeah, I ain't got shit to say. You're not, but these kind of people don't want you to say, so you gotta go. You gotta go. You gotta go. Wait a minute. You be putting your fucking hands on me. No need to what from you. Don't you touch me, nigga. I'm walking. I'm walking down the sidewalk. Now put your hands on me again, and it's gonna be some shit. I'm gonna see how good you is. Now put your hands on me again. Nigga. I'm not trying to fight you. No. You put your hands on me. I'm walking down the sidewalk, and I'm gonna see what happens. Take your stuff and leave. What? Take your stuff and leave it. Now you tell me what the fuck to do. Nigga. You got all this coordinated. And white boys like that. See how black, whites, and how we fuck that. I ain't kiss my ass. Oh, yeah. Korean. Don't tell. You need to. Go ahead. I tell you what you want to do. What you want to do? Put your hands on me. I'll light you up. And I'm going to knock your motherfucking jaw. You old, so I ain't going to put my hands on you. But I'm going to light you the fuck up. Put your hands on me. Nah, I suggest you keep fucking walking. Because I done been calm. I done been fucking calm. Now I can break your fucking jaw, or you can fucking walk. Yeah, get the fuck out of here, right? Matter of fact, I'm going to put this up for you, right? Now walk up on me, I'm going to knock you the fuck out. So I suggest you go. I'm you bus stop. So this ain't no bus stop. This ain't no bus stop. This ain't no bus stop. So go ahead. I'd have been kind. No. Get listen. Yo, what you want to do? Put your hands on me again, and I'm gonna knock your mother. What's up? You wanna do it like that? What's up? You wanna do it like that?
For the record, that was the first 3 minutes and 37 seconds.
Can you go back to the part right before you went down?
Yes, sir.
There's a glare on the TV, I couldn't really see.
I'm walking, because I done been calm. I done been fucking calm. Now I can break your fucking jaw, or you can fucking walk. Yeah, get the fuck out of here, right? Matter of fact, I'm gonna put this up for you, right? Now walk up on me, I'm gonna knock you the fuck out. So I suggest you go. So this ain't no bus stop. This ain't no bus stop. This ain't no bus stop. So go ahead. I'd have been calm. No. Listen. Yo, what you want to do? Put your hands on me again, and I'm gonna knock your mother. What's up? You wanna do it like that? What's up? You wanna do it like that?
And I would move for the admission of people to exhibit numbers.
Any objection? No objection. Admit.
And people will play through a stipulation, people propose exhibit number 3, which would be surveillance video footage from the business garden bowl located at 4120 Woodward. That was 3 minutes.
Let me see that one more time, that last portion, then I'm gonna see the first video. That's not what it used to be. I'm ready. Okay. Then the first one. Let me see when the officer first arrives.
Department 406, and the entry code is encapsulated.
Hello. You go. Y'all call.
We didn't check it, but he's trying to come back in, also trying to all our security, and then he's what's up, sir? How you doing today? I'm the police. I'm the police too. Gee, I ain't got shit to say. You're not, but these kind of people don't want you to show, so you gotta go. You gotta go. You gotta go. Wait a minute. You be putting your fucking hands. No need to watch from me. Don't you touch me, nigga. I'm walking down the sidewalk. Now put your hands on me again, and it's gonna be some shit. I'm gonna see how good you is. Now put your hands on me again.
I'm not trying to fight you.
No, you put your hands on me. I'm walking down the sidewalk, and I'm gonna see what happens.
Take your stuff and leave.
What?
Take your stuff and leave it.
Don't you tell me what the fuck to do. Nigga. You got all this coordination. And white boys like that. See how black, whites, and how we fuck that. Y'all kiss my ass. Oh, yeah. Don't tell. Nigga,
Go ahead.
I tell you
what you want to do. What you want to do?
Put your hands on me.
I'll light you up.
And I'm gonna knock your motherfucking jaw.
Oh, so I ain't gonna put my hands on you. But I will light you the fuck up.
Put your hands on me.
Nah, I suggest you keep fucking walking. Cause I done been calm. I done been fucking calm. Now I can break your fucking jaw, or you can fucking walk.
Man,
get the fuck out of here, right? Matter of fact, I'm gonna put this up for you, right? If I walk up on me, I'm gonna knock you the fuck out. So I suggest you go.
Bus stop. So
this ain't no bus stop. This ain't no bus stop. So go ahead. I done been calm.
No. Get to listen.
What you want to do?
Put your hands on me again, and I'm gonna knock your mother.
What's up?
You wanna do it like that?
What's up?
You wanna do it like that?
I would look for the admission of people, exhibit three.
Any objection? No objection. Admitted.
And then for stipulation, on people's exhibit, proposed exhibit number 4. It would be, the surveillance video we just saw with Officer Brown's body worn camera audio, put over the top.
Any objection? No. Admitted. Anything else from people?
And I'd ask to play exhibit number 4 for.
So go ahead. Can I just have a second? I have no problem. Okay. That's admitted.
Thank you, Your Honor.
Copy 406. 406. And the entry code is intact for you.
Hello. You boss. Y'all call. Check it, but he's trying to come back in. He wants to fight all our security, and then he's really calling the What's up, sir? How you doing today? I'm the police.
Well, I'm the police too. Gee, you guys just say I'm.
You're not, but these kind of people don't want you to say, so you gotta go. You gotta go. You gotta go.
Wait a minute. You put your fucking hands on
no
me.
need to walk from me.
Don't you touch me, nigga. I'm walking down the sidewalk. Now put your hands on me again, and it's gonna be some shit. I'm gonna see how good you is. Now put your hands on me again.
I'm not trying to fight you.
No. You put your hands on me. I'm walking down the sidewalk, and I'm gonna see what happens.
Take your stuff and leave.
What?
Take your stuff and leave it.
Don't you tell me what the fuck to do? You got all this coordination. And white boys like that. See how black, whites, and how we fuck that. Y'all kiss my ass. Oh, yeah. Yeah.
Go ahead. I tell you what you want to do. What you want to do?
Put your hands on me.
I'll light you up.
And I'm gonna knock your motherfucking jaw.
You old, so I ain't gonna put my hands on you. But I will light you the fuck up.
Put your hands on me.
Nah, I suggest you keep fucking walking. Cause I done been calm. I done been fucking calm. Now I can break your fucking jaw, or you can fucking walk. Yeah, get the fuck out of here, right? Matter of fact, I'm gonna put this up for you, right? You got it. Because I walk up on me, I'm gonna knock you the fuck out. So I suggest you go.
I'm at the bus stop. So
this ain't no bus stop. This ain't no bus stop. This ain't no bus stop. So go ahead. I done been calm.
No.
Listen, what you wanna do?
Put your hands on me again, and I'm gonna knock your mother.
What's up?
You wanna do it like that?
What's up?
You wanna do it like that?
Did the court need to see any of that video a second?
No.
And then there were stipulations between the defense and the people as it relates to the two individuals in that video. The police officer is Officer Juwan Brown, the defendant in this case, and the person who Brown is the deceased, Daryl Vance. It's D-A-R-Y-L, Vance, V-A-N-C-E. The people would also move to admit people proposed exhibit number 1.
Let me report, that's fine.
Let me report. And I agree, pertinent part that the postmortem examination of the body was on Daryl Vance, who was a 70-year-old male who was pronounced deceased at 11:30 hours on September 21st, 2023. And in consideration of the circumstances, postmortem examination, the medical record review, it is my opinion that death was caused by blunt force trauma to the head with complications, and the manner of death is homicide. And if the court would like, I can read the entirety of the report or provide to the court if
Just provide.
May I approach, Your Honor?
Yes.
And then I would also ask that the transcript that was provided to the court to be people proposed exhibit number 5 in that answer.
That's fine, please. Admit it.
And with that, the people address, Your Honor.
I'm going to call Daniel Baldwin. Okay. Baldwin, yes, sir.
Can you leave that?
Sir, please step forward. Give your name and the spelling of your name to the young lady seated over here. Give her your name and spelling, sir. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat in the witness box right next to me. All the way up here, sir? Yes, sir. Voice of nice and loud and speaking to that microphone to your left. In fact, you actually put the microphone up and place it in your lap so you can speak into it, okay? You may begin when you're ready.
Good afternoon, sir. Can you tell us your name, please?
Daniel Baldwin.
And thinking back to September the 1st of 2023, some 4.5 months ago, were you working at the Garden Bowl?
Yes.
And what was your job there at the Garden Bowl?
At the time, I was lead security.
How long had you been at Garden
Bowl? Year.
During that time before September the 1st, had you had occasions where you had to escort people out of the Garden Bowl for whatever reason?
Yes.
And can you tell us, prior to September the 1st of 2023, did you or the manager, Nicholas Stone, in your presence, ever have to call the police to assist with anything that was going on?
Typically, we call the police when they're outside, so we can't do anything with the person while they're out in the street.
On September the 1st of 2023, I think it was somewhere around 6 p.m. But by the way, at some point in time, were you interviewed by some police officers, I think the day after this incident?
It was the day of, and then I was approached by the news.
I forget the news, let's talk about the police.
But that was it.
And you remember them taking a statement from you and you signing that statement?
Yes, sir.
And I've given you that statement, and you can feel free to use it to refresh your memory for anything that you need to refresh your memory on, given that this was going on, okay?
Yeah.
Okay. So,
But Your Honor, I'd ask though that he testify from his memory, not his.
for sure, if you need to refer to it, just let us know, but until then, we want you to testify from you, okay?
Understood?
Okay. On September the 1st of last year, did there come a time where one of the patrons got a little bit unruly in the bar?
Are you talking about this situation or just prior?
No, I'm talking about this one on September 1st, 2023.
Yes, he was unruly in the bar.
And can you give us, without going into great detail, what was he doing that got your attention?
More or less when I got there at 6 p.m., I was getting my radios and stuff ready for the day for me and the guys. As I was coming out the office, I could hear the gentleman yelling at the waitresses, saying that they took his property. And yeah, gotten in his property or knife or something of that sort in his bag. But when I got over there, I was telling the compound he doesn't need to talk to ladies that way. But his bag was right where he left it.
And when you had that conversation with him, did he calm down and start to behave properly?
I mean, for about 3 seconds.
And then what?
Then he just back on to the whole thing.
Can you give the judge an estimate of how long this went on before you and the other security people told him he had to leave?
Well, it was almost immediately because I don't stand for that in the bar. So I needed him out right away.
And tell us, how did you get him to leave the bar? Did you have to escort?
I didn't really escort him. It was just more of me guiding every step towards the door until he got to the door.
And he wound up going out of the door and then he was
Yes.
outside on Woodward, right?
Yes.
You already told us that as security people, you know that you really can't do anything with any civilians once they're outside of the government.
Correct.
Can you give the judge an estimate of how long he was out there before your manager called the police?
Well, he was out there trying to get back in with the issue. That's why we called the police.
And at the time that the police were called, you were aware that he had claimed he had a gun.
He had claimed he had some sort of weapon.
So can you give us an estimate? I know he was trying to get back in, et cetera, and so forth. How long do you think passed before you actually called the police?
It was maybe about 20 minutes, half hour at the most. It wasn't very long because most of that time was me trying to get him to the door without getting hit.
When the police were called, did you expect that a police officer or police officers would show up?
I expected someone would show up.
That's the reason you called the police in the first place. Did you
Yes, sir.
need help, right? Did a police officer appear over there on Woodward in front of the government?
Yes.
And were you outside during the confrontation between the police officer and the man you had told to leave?
I was in the front door, yes.
Did you hear the officer tell this man to leave the area?
Yes.
Can you estimate for the judge how many times you think he said that?
5 times easily.
And did you observe what was going on when the officer was trying to get him to leave?
Yes.
What did the man do? Did he leave?
No.
What did he do?
I kept arguing the point. He didn't have to leave.
Was the man that you had put out of the garden, was he aggressive in terms of how he was interacting with the police officer?
Yes.
What would you mean? Tell Judge King, please. What was aggressive about his behavior?
Well, it was refusal for leaving the property, claiming to be an officer himself. And more or less, he wasn't leaving without a fight.
At some point in time, did you see that man swing at the officer?
The older gentleman,
Yes.
I believe he tried.
What do you mean when you say that?
Well, it's kind of hard to say. Like someone's so drunk, anything, they do all their movements are erratic. So there's times when I'm at the bar, people claim to have swung at me, but it was just more or less than trying to get off of that. But yeah, I believe he kind of tried, but he was drunk. He was drunk. It was hard for me to really think it was even a swing.
Do you remember being asked that question? And I know you got the thing all rolled up. Remember being asked that question by the officers when they talked to you? I want you to look at the bottom of the first page. Look at the last sentence. Read it to yourself and see if that refreshes your recollection as to whether you saw him swing on the officer.
Yes. So, I mean, he hit the officer.
Okay, that's all I was trying to find out. I don't have anything further. Thank you. Cross-examine?
Yes, Your Honor. Now, Mr. Ball, I have a few questions.
Sure.
You described the individual heavily intoxicated.
Yes.
In your statement. And what made you believe him to be heavily intoxicated?
Well, slurred speech, the smell, his aggression, the fact that he didn't know where his bag was when it was right next to him where he was sitting. Stumbling.
Very unsteady on his feet, would that be fair to say? Did you view the individual, Mr. Vance, as any kind of threat to yourself?
Is that the older gentleman? I don't know.
The older gentleman who ultimately was not unconscious at the carnival, did you view him as a threat?
I did.
Why did you view him?
Because he kept balling his fist at me and then threatened to one-on-one fight my partner inside the carnival.
And you indicated that many times when you've been working, people have been very drunk and they thought they threw a punch at you, and it really didn't end up being a punch, right?
Never didn't feel like one. In the moment, it's hard to tell.
I'd like to play you people's exhibit number 4. You indicated that the individual tried to hit the officer.
Yeah.
I just want you to watch this and tell me at what point that happened. I would stop it at 16 seconds. Are you anywhere on that video, sir?
Yes, I am. Yes, I am.
And can you describe what you're wearing in that video?
My security uniform.
Are you the individual standing close to the patio area?
Yes, I am.
And is that the individual who was ultimately knocked unconscious and was the unruly patron?
Directly in front of me, yes, it is.
Okay, thank you. Thank you. Keep watching and tell me to stop when you see the punch first.
Department 406, 406, and the entry code is inbound for you.
Hello. Because y'all caught. Didn't check it, but he's trying to come back in all our security, and then he's like really far with What's up, sir? How you doing today? I'm the police. Well, I'm the police. Gee, I ain't got shit say you not, but these kind of people don't want you here, sir, so you gotta go. You gotta go. You gotta go.
Wait a minute, you be putting your fucking hands on me.
No need to walk from me.
Don't you touch me, nigga.
Where you going? Where you
I'm
going?
walking down the sidewalk. Now put your hands on me again, and it's gonna be some shit. I'm gonna see how good you is. Now put your hands on me again.
I'm not trying to fight you.
No, you put your hands on me. I'm walking down the sidewalk, and I'm gonna see what happens.
Take your stuff and leave.
What?
Take your stuff and leave it.
Don't you tell me what the fuck to do? Nigga. You got all this coordinated. And white boys like that. See how black, white, and how we fuck that against my ass. Oh, yeah. Don't tell me.
Go ahead.
I tell you
what you want to do. What you want to do?
Put your hands on me.
I'll light you up.
And I'm gonna knock your motherfucking jaw.
Oh, so I ain't gonna put my hands on you. But I will light you the fuck up.
Put your hands on me.
Nah, I suggest you keep fucking walking. Cause I done been calm. I done been fucking calm. Now I can break your fucking jaw, or you can fucking walk. Yeah, get the fuck out of here, right? Matter of fact, I'm gonna put this up for you, right? You better, if I walk up on me, I'm gonna knock you the fuck out. So I suggest you go.
The bus stop. So
this ain't no bus stop. This ain't no bus stop. This ain't no bus stop. So go ahead. I done been calm.
No.
Listen, what you wanna do?
Put your hands on me again, and I'm gonna knock your mother.
What's up?
You wanna do it like that?
What's up?
You wanna do it like that?
My thought was right before the couple was on the insurance show.
Your angle, so this is on the video, reflect on the video?
No, it doesn't show what I saw on the video.
Okay, so on the video, it doesn't reflect what you believe is.
Yeah. My angle looked like, after the initial push, he came back at him aggressively and then they started wrestling. So.
And now you saw yourself on that video. At any point in time during that video, were you in fear of your safety?
I mean, I was never in fear of my safety, but I was more in fear of the safety of the women and kids that were in the bar.
Nothing else, sir.
You redirect?
Just one thing. I think what I heard you say, Mr. Baldwin, is you looked at the video is whatever it is, you saw the man swing.
Well, like I said before, I mean, when someone comes at you aggressively, it all depends on that serious moment. It looked like he was either gonna grapple with them or just a slight swing.
Okay, thank you, sir.
Thank you, sir. You may stand.
Thank you.
That's all of our witnesses.
The people would move for the court to bind over on both counts, count 1, homicide, manslaughter, involuntary, and count 2, common law offenses, misconduct. And I would reserve my conclusion.
I gave the court a memo anticipating what we would see today, and the memo pretty much states my position. I think that the totality of the circumstances here, and we haven't really talked about, although I put it in the memo, what Mr. Vance was really doing, in addition to the fact that he was coming at the officer, he was also resisting and obstructing by the definition of the statute. And Officer Brown had every right to arrest him for that. He told him how many times or how many minutes, and he wasn't obeying the order. But it's our position, Judge, that based on what you saw, and given the fact that the Supreme Court has said over and over again, including in Officer Krokvik's case, when you dismissed the case and examined it, appealed it all the way up, you have the right as the examining magistrate to make factual findings. And it's clear from the video and clear from the testimony of the witness, it seems to me, that Officer Brown was acting in self-defense. He's a police officer. He's called to the scene. He starts out, as we can see in the video, He's trying to talk with the man, he's trying to talk nice with the man, he's trying to tell him to move on. The man, for whatever reason, starts calling him names and starts approaching him, coming at him all the time. Obviously, the fact that he's older, you look back and you say, well, he's old. I mean, I'm gonna be 75 in March. If you let me swing on you, I can still do some damage. Not like I could have done at 55 or 50. But I mean,
I'm sorry to be the laugh.
that's okay. That's, you know, I'm an old person. So I think you have to take things into totality here, as I try to do in my memo. And I think this court should make a finding that, let me just find the language real quickly. I highlighted it for you. It came from the Anderson case. It's on page 7 of my memo. And I highlighted it that the magistrate has the right and the duty to determine, quote, whether the evidence presented is sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused guilt. I say that the video says it, the audio says it, the witness, Mr. Baldwin, says it, that there is not a way that you should say that you have a conscientiously held view that there's a reasonable chance that Officer Brown is going to be found guilty. That's with respect to count 1. Count 2, I don't know how the prosecution gets around the language of the case law. And the court's very, very familiar with the case law, because I think this is the identical memo with respect to this count that I submitted to you years ago with Officer Kropat's case. But the jury instruction requires, in order to be convicted of misconduct of the officer, in this case, the officer, he has to act with a corrupt intent, or in other words, with a sense of depravity, perversion, or taint. I just don't see anything in here that says that he was acting with a sense of depravity, perversion, or taint, with a corrupt intent. He's doing his job as a police officer. He's called to the scene. He sees what he sees. He tries to get the man to leave. The man won't leave. The man swings at him, he swings back, and here we are. But I don't see anything in there that suggests that he was operating with a corrupt intent or with a sense of depravity, perversion, or taint. And so I'm asking the court to do the exact same thing I asked you in other cases, including Officer Kropat's case, to make the finding that you cannot say that they're, with that language again, the evidence isn't sufficient to cause a person of ordinary prudence to conscientiously entertain a reasonable belief of Officer Brown's guilt. I think the court should dismiss the case.
All right, response. Firstly, I'll address the Anderson case of defenses is given for a reason why you should weigh all the evidence, and that is correct. But the case also indicates on page 188, none of this suggests that a magistrate may weigh witnesses' credibility in the same manner as a jury. While a jury may find a defendant guilty beyond a reasonable doubt, a magistrate must only determine that there's probable cause to believe that a defendant has committed a crime. The gap between probable cause and guilt beyond a reasonable doubt is broad. Therefore, unlike a jury, a magistrate may legitimately find probable cause while personally entertaining some reservations regarding it. So this is just a probable cause standard, and I believe the people have more than met their burden as it relates to both counts in this case. As it relates to count 2, the misconduct in office, it requires that 1, the defendant be a public officer. In this case, it's a police officer, which meets that definition.
Let me ask you a question. It's just burning in my mind right now. As it relates to count 2, common law offenses, misconduct in office using excessive force. What was excessive?
Excessive force would have been the assault, the knocking the defendant or the complainant in this case with a punch. There was no need for that. We have to look at the case law is very clear. It's a reasonable, what a reasonable officer would do.
What would a reasonable officer have done?
A reasonable officer could have called for backup to de-escalate the situation. A reasonable officer could have
calling for backup to de-escalate that situation. It didn't sound like it's not for all intended purposes was disorder, to say the least. How is more officers going to de-escalate the situation?
Well, as it relates to being disorderly, it Lofty multiple times that he would fight the officer. In fact, I caught 1, 2, 3, 4 times. During those 4 times, the officer didn't indicate that he was going to be placed under arrest. Didn't seem to be in fear of those assault batteries. It appeared to me that this is a drunk 7-year-old individual who's unsteady on his feet, who allegedly there was mention that there could have been a weapon. It didn't seem to put the officer in fear of allegedly his bag. He never checked the bag, never went to the bag. The complainant in this case didn't even have the weapon or the bag in his possession at the time it happened. Further, the officer abused the
Let's
fear.
play make believe just for a second. Let's play make believe and say that instead of the officer hitting this unit, that he pulls that taser out, he hits him with the taser, and the taser causes his death. That have been excessive force?
That would be a hypothetical that potentially could be based on the circumstances. There is policy manual that says they're not supposed to use a taser on an individual that age. But if he was in fear of that individual when he pulled the taser, he put the taser away. He didn't just watch the defendant. He in fact enticed the defendant. He poked the defendant and came back with his arms cocked, ready to fight the victim. Is what the defendant was doing. So it wasn't that he was trying to put him under arrest. He didn't say you're under arrest. I'm going to put you under arrest. In fact, his own words were, "If you don't, now I suggest you keep fucking walking because I done been home. I done been fucking home. Now I can break your fucking jaw or you can fucking walk." Another instance, now walk up on me again, I'm gonna knock you the fuck out. So I suggest you go. At no point does he say you're gonna be placed under arrest. It looks like the officer who's by hurt, who's decided he's gonna use excessive force, which a reasonable officer would not have used to fight the victim. Put his hands in a cocked position, he was ready, looking for a fight. At no point did he attempt to indicate he will be placed under arrest. Except for those reasons, I'd ask him fine. And clearly as it relates to manslaughter, the battery from the officer is what caused the deceased to become deceased, Mr. Vance to become deceased. His own words show his intent that he intended to cause harm. So I'll break your fucking jaw, I'll knock you out. Those aren't the words of an officer trying to de-escalate a situation. Those aren't the words of an officer trying to uphold his standards and what a reasonable officer would do, and making sure that he's using the least force possible. Excessive force requires allows you to use force, but not excessive force. In this case, he didn't try and put the individual in handcuffs, tapped at him to get him ready to try and get him to fight, and then he raised his fist first. And then he ultimately the only individual who threw any kind of physical contact.
You say that, I saw it on the story.
Your Honor, and I would disagree. Or there's a punch thrown. It's him trying to push backwards. It's not any
Absolutely
kind of punch.
not. I saw a punch thrown. I know I'm not seeing things. Well, play it back. Play it back. Right before he goes down. Not sure what happened to my TV. What you guys do to it?
1 second, just turn it off.
Okay.
You wanna do it like that?
You didn't see that with his left hand? Actually, made contact.
What's up? You wanna do it like that? You wanna do it like that?
The officer did he was with right.
I think that's the officers pushing. They're pushing and then, but it's clearly a punch.
Wait a minute, you didn't see the left hand extended?
Your Honor, I don't see it as a punch or a swing, and I asked the individual who was
You might want
there.
to stand close like I did. Play it one more time.
Do it like that. You wanna do it like that?
Yeah, with the left hand.
And Your Honor, to me, I don't see a punch. I think we have a difference in. I'm looking at the same thing you are. And with that, I'd ask the court find over.
Anything else?
I guess as it relates to misconduct in office, defense may mention that it doesn't believe the taint, the property of perversion fits. Taint is a trace of something bad or offensive. To me, enticing somebody into fighting and then throwing the punch with something bad or offensive. The property is being betrayed, trade is normally defined as morally corrupt or perverted. I think it would appear to me looking like trying to have a boxing match individual is certainly morally corrupt. Perversion is the act of perverting. The term perverted includes in its definition misguided, distorted, misinterpreted, term was considered right or true. The true thing would have been placing him under arrest, telling you to be placed under arrest, not if you don't walk away, I'm going to knock you pretty good monthly job. And I asked the court final version.
All right, so one of the most unusual exams is that people didn't put on any live witnesses, just relied on video and transcribed testimony or statements that were made by the parties involved, which is fine. The video speaks volumes. So I will first of all acknowledge that our police officers have a very dangerous job. I have no idea what they're walking into on a daily basis, what they're coming upon. And you have people that are disorderly, whether it be because they are drunk or under the influence of some kind of drugs or narcotics, whatever the case may be. We don't know what danger awaits them. This officer gets out the vehicle. He addresses the parties, he's trying to find out what's going on. He's telling them, he tells the gentleman that these people don't want you here, you have to move on. The elderly gentleman gets irate, uses all kinds of profanity and the like. The officer tells him to move on, says, don't put your effing hands on me, pushes him away a few times, as the guy kept coming towards him and invading his space. So if I'm a police officer, I want a clear space between the two. I don't want him to swing on me or to grab a weapon from somewhere to be able to use on me. So I'm going to keep you at bay. So I have no issue with the officer doing that. All this banter going back and forth about what the parties are going to do, that's really at no consequence. He telling him, I'm going to break your effing jaw. Don't come on, don't walk up on me. You know, under the circumstances and what this defendant is saying, I can certainly understand. I don't necessarily condone, but I can certainly understand the officer saying what he said. You're trying to keep space between them. He at one time pulls out his taser, decides not to use the taser. Probably be here for a whole different reason had he done so. So I'm wondering, what position do we leave our officers in if have someone that's totally disorderly, not obeying the lawful commands of a police officer, resisting and obstructing, doing all these things, just not listening to the officer, keeps coming back and saying what he's going to do. What would a reasonable officer have done in that situation? People answered that question by saying, call for backup. Well, what is backup going to do? Backup is going to come and do and say the same things that he said. Move on. You can't tell me what to do. I'm at the bus stop. I'm walking down the sidewalk. All of these things. It's very unfortunate and certainly not intentional, and I'm sure that's why it's charged as involuntary manslaughter. But where is the gross negligence? Because the guy is elderly? Did he hit him? Now, I will acknowledge that I saw the officer step towards him first and extend his arms. And when he did so, that's when the deceased extended his left hand and made contact with the officer's right side of his head, chin, neck area, and his head actually went back. And then punch came from the officer, and the guy goes down. I don't know if I'm ready to concede that that's excessive in light of the circumstances. I don't think that's excessive force. So, as it relates to count 2, did commit an indictable offense in common law, misconduct in office by using excessive force against Darrell Vance. I just don't see that enforcement is excessive. court is not satisfied with the burden of probable cause as relates to count two common law offenses, misconduct in office. The involuntary manslaughter did cause the death of Daryl Banks. I don't think that's in dispute. That he did cause the death of Daryl Banks by following the unlawful act with intent to injure by assault and battery. Was this an assault and battery? That's the question I would have to decide. Was this an assault and battery? Or was this an officer discharging his duties as a police officer and trying to get this disorderly person away from this establishment? And the disorderly person refusing to do so engages the officer and at some point does extend his left hand and hits the officer. After that was done, the officer hit him and down he went. I don't know if anybody can reasonably expect that he would have died from that. It's a very difficult situation because I do have a 70-year-old man that's now deceased. But the question is, did he cause his own peril by his own actions? Or was this officer grossly negligent in assaulting the 70-year-old man? So first I have to cross that bridge that he first assaulted. I'm not sure I'm prepared to do that either. So as it relates to count one, the court is not satisfied with the burden of probable cause as it relates to the involuntary manslaughter either. Case will be dismissed. Thank you, Judge. I think we dismiss the order. You guys want this stuff back?
Absolutely.
Oh, I was just saying.
See, I'm looking.
I see two files. I see two files.
Judge, it was a pleasure. All right. I can't say I'll be back again, but, all right. Okay.
When I see you coming, I know it's trouble.
Have a good one. Thank you, Judge. Oh, wait, I have to tell you a quick story. Like you said there, crime murder case, when it Terry years ago. Defendant gets found not guilty. And that was in the days, way back when they let the guy right out, and you have to go back to the jail. We walk out, I think there's 2 or 3 of the female jurors, and they just happen to be out there. They come up to mid-length, mid-black, they come up. Mr. St. You stay out of color. So he goes his way, and me and one of the jurors are walking, and I said, Mrs. Smith, I said, I heard what you told me, there's only one time. He is trouble. Everybody goes to trouble.
Three, because he told me it would have been 2. Because you told me the space. So.
Oh.
You want yours in space?
Where the plane? Where the plane? Up here.
Yeah.
That's a misprint.
Well, you can be buying lunch again next week. Well, you'll be buying lunch again next week. 3 o'clock. Yeah, 3 o'clock is out tomorrow.
Oh. Tomorrow must be Friday.
See you tomorrow.
Get that? That case of the lady got ran over by the bus. It was a homicide. Oh, that's not, I thought that was gonna be that. Of course it was. Yeah, tomorrow. That concludes the docket for today, folks. Hope to see you tomorrow, same bat station, same bat. Well, that comes.